Welcome back to day 2 of We Robot. It's exciting to welcome you back. I hope you enjoyed yesterday's panel. I hope you enjoyed the dinner last night. I'm excited for another superstar lineup day today with some amazing papers. And I'm going to go ahead and get started. I know we're a few minutes late, so we're going to move some. I'm going to work the schedule back just a little bit, but stay tuned for how we're going to do that. Just a few announcements. One, just a reminder that this is in fact an open building, and so when you leave, please don't leave your bags over in the atrium area, just because there's not going to be anyone watching them. They should be here, and we can stack them up over there. That's just fine. Also, when you go to lunch, I had also had high hopes again for lunch to be outside on the BU beach, which, as you figured out by now, is not in fact an actual beach, but sort of a joke. Not a joke as in like ridiculous, it's actually quite beautiful, but there is no sand. Third, someone left this coat at Stacy Dogan's house. I'm taking bids on it if you want. Do I hear 20, 30? No? Okay. If it is yours, please come to me.
Are you giving that to me?
No, I'll keep it right. If it's yours, you have to describe it in the images. Finally, if you are an author on the poster session, we thought it would be a great idea to continue to display the posters throughout the day if you want to see more about them. But if you want to keep the posters, please take them down by the end of the last session because we'll just sort of clean them up afterwards. But if you don't want to keep them, that's fine, and we'll take care of them. All right. Finally, I want to again give a huge thanks to our sponsors, without which We Robot would not be possible. Our sponsors are the reasons that we are able to have this event at all, but particularly the really nice dinner and other amenities that we've had here. So a huge thank you for that. And without further ado, we have our next panel. Meredith, would you please like to take us away?
Okay, hi everybody. I'm Meredith Broussard, and I am here with Max Isaacs, and we are going to talk about a terrific paper on regulating police robots. So let me pull this up. Okay. Let me tell you about what happens in this paper. In this paper, authors Max Isaacs, Barry Friedman, and Farhan Haidari cover uses of police robots, and they offer some considerations for regulating police robots. The paper is organized in 3 parts. We've got a landscape survey, risks and benefits, and regulation, and the latter includes the current state of regulation plus some speculative regulation. They give us some scenarios about current uses, like police robots are responding to emergency calls, surveying accident sites, and conducting patrols. Robots are being used to locate missing persons and reach barricaded suspects. They are collecting evidence, identifying scofflaws, and in rare instances, deploying force. These are primarily in New York and California, 2 of the wealthiest states with the best funded police forces. The authors write, quote, "In general, there is far too little regulation of policing technologies. There's a panoply of reasons why this is so, from anti-regulatory pressures from police unions and organizations to a lack of information and expertise on the part of lawmakers. Vendors, too, play a key role. Competition between tech vendors has created a race to the bottom in which ever more intrusive products are brought to the market with little to no public engagement." End quote. Some regulatory efforts exist. The authors tell us that legislation has been proposed in New York prohibiting the use of robotic force, while a California bill would prohibit police from using weaponized robots absent local democratic authorization. We also have something in Rhode Island. Regulation of police aerial drones is a little further along, so 20 states with laws regulating police drones. Only 7 states have addressed the weaponization of drones. Although weaponization is prohibited by FAA regulations, only to address the use of facial recognition of drones. So that's the state of where we are in terms of regulated police robots, and we can agree with the authors that it is indeed anemic. The authors explore whether police robots should be treated exceptionally under the law. That is, whether they should play by a different set of rules than human officers. And they call it a difficult question. I do not think it is difficult. Yes, robots have to obey the law of the land, and so do police. So perhaps we could talk about that. The authors ask 3 questions. First, do we want robots to be performing this function in the first place? After all, what might be considered routine and accepted activities for human officers may be highly controversial activities for a robot to perform. Second, is there a reason why robots should be afforded the same latitude as is afforded human officers? The degree of latitude may need to be reevaluated when officers are kept out of harm's way. Third, and finally, are the harms that existing regulation seeks to address present in the context of police robots? If so, there's a strong argument to be made in favor of regulatory parity. They add, however, that a caveat is in order. Extending existing rules to robots, while a step in the right direction, may not go far enough. Sorry, I lost my place. For one, police are vastly underregulated along a number of dimensions. There are, moreover, harms unique to police robots which would not be addressed adequately through existing rules governing officer conduct. Parity is not enough. What ultimately is needed is a broader regulatory framework. So what does regulation look like? It includes transparency, legislative authorization, diversion to non-police agencies, video recording, I'm not excited about this one, and data regulation. The authors explore the implications of autonomous weapons and use of force by police robots, which they consider a non-starter. I was very happy about that part. And there must be rules around enforcement, and robotic use of force standards must be far more stringent than those applicable to human officers. There should be strong de-escalation requirements. Robots should be used only when they can be less lethal. We talked about new use of force. Another important point, all uses of force should be subject to independent and public after-action reviews. So deployment decisions, they argue, should be left in the hands of democratically elected officials. I am not convinced this is a good idea, given the low level of technological literacy among officials and the general public, but we'll return to that. They also look at requirements for vendors, that they stop lying or exaggerating the capabilities of robots, and discuss remedies for inevitable harms. I found the part about harms very intriguing. The authors begin with a discussion of qualified immunity, a doctrine which immunizes police from liability unless they have violated a clearly established statutory or constitutional right. Qualified immunity, they write, is enormously consequential in litigation involving police and will undoubtedly affect the extent to which victims can recover for harms caused by police robots. And then they turn to the question of whether police or vendors should be held liable for harms caused by police robots, and they address the likelihood that even with strong safeguards in place, police robots will cause harms that will not be redressed sufficiently in the courts. They propose a novel solution, a mechanism for compensating victims of police robots outside of the legal system. So this victim compensation fund is an interesting idea. It gets ahead of the inevitable, admitting that there will be harm, and provides in advance for restitution. And the model for this is the vaccine restitution fund. But now we're into liability. So who is liable for a robot harm, the police or the vendors? The authors look at self-driving car law, which is deeply problematic given the degree of regulatory capture. in the self-driving car space. This is one of two logical points where I would argue that the paper could be strengthened. The authors write that a key premise of self-driving cars is that, in general, they are safer than human drivers. And so in Artificial Unintelligence, I showed that this contention was manufactured by a drone manufacturer and is almost entirely imaginary. I would also suggest that the authors engage more with an obvious regulatory strategy, which is banning the use of certain types of police robots, especially the ones that can cause grievous bodily harm. The police have shown themselves to be inexpert at using sophisticated technologies. So if we look at crime data, especially hate crime data, it's a huge mess. Police departments are not good at reporting data, which is incredibly easy to do. I worked with ProPublica on a project called Documenting Hate, where we looked at FBI uniform crime data for hate crimes. It was hugely inadequate, and so ProPublica went and collected hate crime data from individual police precincts and counties all over the country. Some of them came in lovely data form. Others of them were handwritten on forms. And this is what they thought was adequate to report to the FBI. And this was the level of sophistication at multiple precincts. We also have, of course, the examples of police using facial recognition and doing and catching up, doing mismatches using facial recognition, and innocent people end up getting caught up in the criminal justice system inappropriately. So we have lots of examples of this. The authors offer a case study of drone first responders. The idea is that they would send a drone to be a first responder instead of an officer. Maybe we can increase capacity this way. I read this and I wondered, what about the weather? So yesterday, New York flooded. How is a drone going to help in that situation? Drone first responder enthusiasts cite the reduced response time for drones, saying that a drone could shoot video and send it back to the police station, which does seem kind of great. But then I wondered, why not just FaceTime the person? Okay. Why isn't there a 911 app nationally that has video capabilities? Why are we still messing around with 911 and bad geolocation? Okay. So I wanted to talk about police use of technology that is far less sophisticated than robots, and getting that going before we talk about police use of robots, or before we let police have robots. Data retention policies are going to be important, as the authors write. But right now, data retention policies among police are poorly implemented. Gang databases, for example, are often secret and have no data retention policies. The way that gang membership works is that people age out of gangs generally, but people can't get out of gang databases if there's not a good data retention policy and a deletion policy, and if the databases are secret and then you get stuck in the database, like, it's a mess. The police themselves have a gang problem. White nationalist gangs are common among America's police forces. A quick search reveals that even back in 2006, the FBI was aware of white nationalists and skinheads infiltrating police in order to disrupt investigations against fellow members and recruit other supremacists. Law enforcement in the US began as patrols to catch and punish enslaved people. These are not groups who have proven themselves to be reliably expert users of technology or good at self-critique. And they don't need more weapons to deploy against vulnerable communities, especially communities of color. So in my last book, More Than a Glitch, Confronting Race, Gender, and Ability Bias in Tech, I wrote of a number of misuses of tech in the criminal justice system. I wrote about a predictive policing model that was deployed to predict future criminals, and then ended up getting deployed against children, using their attendance records at school to predict whether they were going to be criminals. There was a computational model that was used to try and predict gun violence that ended up getting somebody shot because the police kept coming back after the gentleman who had been identified said, no, I'm not interested in your model. So maybe this is also part of a conversation about who should be allowed to use which robots in which context. Maybe we also need very strict licensing for any police experimentation with robots. Okay, I'm sorry if this messes up anybody's business plans. The scenario of using police robots is really fun to imagine, but law enforcement is a uniquely difficult space for robotics. Robots are machines that are good at repetitive automated tasks, and policing is the opposite. Police, in their best incarnation, deal with really different situations all the time. They deal with wild animals, domestic violence, fender benders, floods. It's the very definition of random events. And so policing, I would argue, is the wrong target for robotic automation. So let's use robots, but let's restrict them to mundane uses or controlled situations. One principle of good technological design is the idea that we should listen to affected communities. And many affected communities are saying that they don't want police robots or increased surveillance. And so we could listen. Okay. Thank you.
Well, thanks for that terrific feedback. I think I agree with just about everything that you said. The first thing that kind of stuck out to me was, this idea of robots playing by the rules. And, at one level, I think I agree completely. If there are rules that regulate police, they should apply to humans. I think the distinction that we're trying to make is between this idea of sort of empowering and constraining rules, because you can end up with a situation where you end up with an over-inclusive rule because, for example, judicial doctrines afford police a lot of discretion, which we would categorize as an empowering rule. And were that discretion to be given to robots, one could imagine, for example, the discretion to conduct a protective frisk during a stop. That would be deeply concerning. But to another point that you made, one should question whether we want police to be using robots like that at all. Maybe they should be used for more mundane uses, and I think that is primarily how most police robots have been used today for bomb disposal. Maybe it's not mundane, but it's sort of something that's accepted. This, I think, goes to a broader point, which is that the extent to which police need authorization to adopt police technology and deploy it, I think depends in part on the impact that use will have on civil rights and civil liberties. And so when we're talking about bomb disposal, which, ostensibly might have some implications if they're cameras or things of that nature, but generally is not of the highest concern from a civil rights perspective, maybe that's an example where less regulation or rather less need for democratic authorization would be appropriate. One of the interesting issues is the issue about deployment decisions. And again, I agree completely that most local lawmakers do not have the technical expertise to determine how to deploy policing technology effectively. Neither do the policing agencies and the police chiefs. They similarly lack the sophistication. And one thing that I think is driving that recommendation has to do with the idea of process. Because so often, essentially what we're talking about is a question of values. You have efficiency, equity trade-offs. You can have the surveillance in the place where it would be most efficient, but that would cause disparate impacts on over-policed communities. Or you could try to spread the surveillance out, and then maybe it would become less effective. A policy choice like that, I don't think ought to be left to the discretion of a police chief. Now, I don't know if the city council is the best entity to make that decision either. I think in part we're suggesting that because they're democratically accountable, and so it's the type of decision that if the public didn't like, they could say, hey, take issue with this decision, and there are political consequences. But I completely agree that at this point, I don't think anyone in local government is particularly equipped to make those decisions. The self-driving car, that is so interesting, and obviously I need to do more research. That is really surprising to me that this idea that self-driving cars are safer is not based in reality. And so I think that's obviously something that we're going to need to address in the paper. I think it actually might make even stronger the contention that we need more regulation of police robots. And I think this also raises the question of, in the paper we don't really talk that much about capture. I think this is a really important point. We had written a paper 2 years ago about the idea of a certification entity for policing technologies. And one of the reasons why we concluded that it would be very difficult to pull such a thing off is precisely because of regulatory capture. So I think that's an extremely important point. And then, finally, I think I'll just say that I agree that we should regulate the technologies before robots. And that's sort of the mission of or one of the missions of our organization and the work that we do. Boy, it's hard to get regulation going at the local level, state level, certainly the federal level. And part of what intrigues me about regulating police robots is that these existing technologies are cropping up in a new context. There's something novel about it, which can animate a desire for regulation. ALPR has been around since like the 1980s, and still only like 17 or 18 states have. ALPR is meaning automated license plate readers. They're cameras that can detect your license plate and tag you with geolocation data so that the police can track your movements over time. This is a technology that's been around for so long. This is a technology that I work on personally, and time and again, people say, well, what's the big deal? Something changes once the ALPR is on a robot, and it's really hard for me to articulate what that is, but it feels like potentially a door opening to regulation of the technology because they're being implemented in some novel capacity.
I wonder if that novelty is the thing that catches people's attention, right? Because I think a lot about algorithms and the way that social media algorithms optimize for attention. And so one of the things they do is they minimize the amount of mundane, and then they look for things that are outside of your regular field of, outside the mundane, right? And so that's one of the ways that they keep attention, right? So I'm thinking about license plate readers and how they're on police cars, right?
Yep.
So the ALPR on the car is not that different than the ALPR on the robot, but somehow on the robot it's like, oh my God, that's different. I'm going to pay attention to it now.
Yep.
So I'm really intrigued by this idea that the novelty of the new technology is an opportunity to talk about regulation and an opportunity to talk about regulating all the other stuff that people are bored of talking about, right?
Yep, absolutely.
I also, I do this thing with my class where I take them, I make them read this book called Networks of New York. If you haven't read this book, it's amazing. It's all about the technology infrastructure of New York City. You're gonna love it. And one of the things that the author Ingrid Burrington writes about is ALPRs. And so then I take them on like a little tour of the East Village, and we look for surveillance technology in the East Village, and we look at the license plate readers, and like we look at the shot spotter cameras and the whatever other stuff that's going on. And so one time we're doing this, and we run into this guy who's working on the traffic lights. And he's like, oh, hey, let me show you how this works. So he just goes over and like opens up the traffic light box at Astor Place, and then just like turns off all the traffic lights to just like show us how cool this is, right? And then he starts telling us about the ALPR system, and about all of the license plate readers that are tracking you, like basically from the Lincoln Tunnel in Midtown all the way down to the Battery Park Tunnel. And then he starts like explaining, the surveillance technology, and it horrified me. But it was the novelty of just meeting this guy on Astor Place and like watching him turn off the traffic lights that made me think about something mundane, like, oh, this is the infrastructure and it's just controlled by regular people.
And part of what's interesting about that story, I think, is because, years ago, ALPRs were this very expensive technology, and now every camera's an ALPR. They say ALPR software. And so there's been this sort of creeping advance of the surveillance technology, and at no point, there was ever a point at which we just had a discussion as a society, city council held hearings and said, do we want this stuff to begin with?
Yeah.
It was just a steady creep to the point where now the tracking capabilities of the NYPD and many other large agencies is just astonishing. And I think, again, that just goes to the point that you were making earlier and that I've made, which is that regulation is really hard, and that if there's something that can break the logjam and sort of push forward, not just on robots, but ALPRs, facial recognition, that might be something worth doing.
Yeah, great. All right, it looks like we have some questions. Let's go to the audience. Oh my God, look at this live! Okay.
And also, just in the interest of everybody, don't feel like you need to respond to everything. There's going to be a lot of questions, and so sometimes it's more effective just to, I think, either short responses or none at all, and everyone will understand. So, thank you.
Thank you for the paper and thank you for the discussion. Great. I'm Peter Rosero from the New School in New York. So I've got so many things to say about this paper, but I'm going to try to limit it for now, and we can talk more later and have some other papers that you should look at, including one from Robot 2016, which is Will Black Lives Matter to Robocop. So we've talked about quite a few of these things. But I want to focus in on the use of force in particular. I like that you conclude that we don't want autonomous weapons. We should strictly regulate the use of force. But I think there's actually much stronger arguments to be made for not allowing robots to be weaponized at all, and actually for not allowing them to use force at all. Because most of the basis for the justification of police use of force is either self-defense or defense of another. So a robot would have no right to self-defense because it's not a person. So that is completely eliminated. And in terms of intervening to protect another person, you would have to understand intention to commit harm and physical capability to commit harm. And any robot that would be sophisticated enough to understand those two things should also be sophisticated enough to intervene either psychologically and convince a person not to commit harm or de-escalate the situation, or sacrifice itself to protect the other person in almost all circumstances. So there should be no real justification for use of force. So I think it's an easy case to just ban that all across the board for all police robots, and probably all robots. And then I think the other one to consider that you don't really talk about is arrest or apprehension, or I don't know what else you might call it, detaining, which might not be a physical detention. If you just ask somebody to stand by, that might be okay. But any kind of physical, like handcuffing somebody, should also probably be prohibited, and interestingly is included in the new Massachusetts proposed law Brandon Schulman was talking about the other day as one of the conditions that the robot should arrest people. So just hope you think about that and have to talk more.
Thanks for the comment. So I'm actually not in favor of the weaponization of robots. I think part of what we were trying to do is say, we think the jurisdictions might come to different conclusions on the issue. If they do decide to authorize, we really need regulation. But one thing, and again, I'm not advocating in favor of weaponizing robots, but there's a situation where police might be using a police robot to protect others. There's also a situation that happens, unfortunately, all the time, where someone calls 911 and there's a guy having a mental health crisis and has a knife, and people have been dispatched, but they're not able to de-escalate the situation. And there's a situation where they're not an imminent harm to others, but also you can't allow them to continue holding the knife and potentially endangering other people. all of which is to say that I think there are some counter arguments for this idea that it necessarily needs to be one of those two scenarios, and that might be animating some of the reason why companies like Axon and others are exploring this idea. But just to clarify, I'm actually with you. I don't think robots ought to be weaponized.
Yeah, just to follow, I mean, the other big problem is, in this country, every police department sets its own use of force standards, and every state has its own laws around police responsibility for the use of lethal force. So, if you were to design a robot for the U.S. market, it would have to be, customizable for every single police department. So probably the first regulation we need would be like nationwide regulation for the police, as a precursor to any other kind of significant regulation.
Yeah, absolutely.
All right. Maybe I'm going to do moderator privilege here, and I'm just going to try and limit our if we limit each question to like a 2-minute segment, then we will absolutely get through everybody.
We're also going to give you an extra 15 minutes, so we have another half hour.
Oh, okay, cool. Well, then you get 4 minutes. Don't use it.
I
Don't
promise
use it
I
all.
won't take 4 minutes.
Okay.
So Price Michigan, I just wanted to say I was so excited by the first line of the paper and so sad because the first line of the paper didn't come up in more of the paper, which is the first line is about robots are no longer this subject of science fiction. And initially I thought this was a silly thing to think, that I regret that there wasn't science fiction here, but as I thought about it more, I thought, no, it's actually not silly in respect of the final paper of this session about techno-legal imaginaries, thinking about the piece yesterday about vulnerability and the discussion that we had about the idea of us conceiving ourselves as vulnerable and the resistance that we face to the idea of conceiving ourselves as vulnerable. And I'm curious, and I suspect this is not your paper, but maybe it's a future one, or maybe it is. I'm really curious about the idea that this is a space where science fiction has said so much about, or has presented in so much detail, the role of robots in policing in particular, outside unlike lots of other contexts. And I wonder how much that's shaped the reflection of the communities whose buy-in is necessary to make this a potentially useful technology. And I don't know what to do from there, but I'm just really curious about it. And if you have thoughts, I'd love to hear them either now or some other time, and you may not, and that's totally fine too. But the paper's really fun.
Thank you. That's a fascinating comment. When we wrote that line, I don't think we were thinking that expansively, but I think you're absolutely right. I think there probably is a lot that we can learn from science fiction and from how that shaped the way that we think about technology, and that's definitely something we want to look into. But yeah, as I said, not sort of the intent of the line, but I think you raised a very good point.
All right, we're here.
Cindy Graham, Oregon State University. This is actually sort of a follow-up to that. I am not hearing a lot about what problem robots are solving in police forces. So, whenever somebody wants a new tech or a new idea, I'm like, well, what problem are you solving? Is this the right way to solve it? And so could you talk a little bit about, obviously, I think the automatic license plate recognition started with toll booths, right? Toll booths, and so it's a way to check through one of those. But do we really need that everywhere else, and what problem is it solving? So can you talk a little bit about that?
Yeah, absolutely. So first of all, with all of these policing technologies, our starting point, I work at the policing project. We have an analytical framework for all policing technologies. Question number one is, what problem is this supposed to solve? Part of what we're trying to do in the paper is say, well, we could just say that, here's a problem that will be solved by police robots, but it really depends on how they're used, because police themselves have such disparate functions. Like there's a first response function, there's an enforcing the law function. I don't go into it in the paper, but they're social workers, they're mediators. And so in order to answer the question, I think we have to drill down on one of those functions. And so just to take an example, it wouldn't surprise me, and again, I know there are very thorny questions about whether this would expand the surveillance state, but it wouldn't surprise me if the use of drones as first responders in response to 911 calls might ultimately reduce the number of times they're going to deploy a human officer to the scene, because now you might be able to say, well, actually, somebody reported a suspicious person and it's just some guy walking around and we just don't need to deploy an officer at all. Now, of course, there might be biases influencing that decision, which might lead to a different result. But I think, my thought here is that really it just has to do with what they're buying the robot for And at all times, they need to be clear about why they're acquiring the robot. And they need to say, well, just because you're acquiring the drone for a drone as first responder program doesn't mean that you can use it for force, doesn't mean you can use it for law enforcement. We need to make sure there's not this mission creep, which we've always seen when it comes to policing technology.
All right, over here.
Hi, I'm Andrew Hunt, postdoc at Carnegie Mellon, and I just want to briefly mention consider checking out the work of Tom Williams. He did like a No Justice, No Robots campaign. He's a robotics professor at CU Boulder.
Thank you. Yes, I'll do that. Appreciate it.
Hi, Brendan Schulman from Boston Dynamics. First of all, thank you so much, Max and your colleagues, for writing this paper. We care deeply about these and related issues. In fact, I think as Peter alluded to, we were involved most recently in developing legislation here in Massachusetts with the ACLU that would prohibit the weaponization of virtually all robots, as well as prohibit robots from being used to restrain people. And that legislation also includes provisions relating to police use, including a warrant requirement and transparency in reporting. So we, for a long time, we've had ethical positions in the company with our intent to make sure that the robots are welcome in society, that they're used to help people, not to hurt people. And I think that the work that you're doing on this paper is really, it's really important. And it's not just important in terms of presenting an academic case for regulation, but also to really get the attention of the lawmakers, which is what we want to do. So we want to work with you and others to figure out what are the concerns and risks here with these robots, and how can we get policy in place to address them. So with that in mind, I think I might have 3.5 minutes left to give you some specific feedback. And I'm happy to send this to you later, so you don't need to write it all down. But just to give you a sense of what I think would improve the paper in terms of your ability to persuade lawmakers and other stakeholders that something needs to be done, and what are the kinds of things that the legislation or other forms of policy might actually implement. So, on page 22, the discussion about legislative authorization, I'm in agreement with Meredith's comment at the beginning of your discussion here, that I'm not persuaded that legislative approval, like specific authorization is a smart path for this kind of technology. If other police tools were required to be approved by city council, and that, we're seeing that in the case of the California statute that does require police departments in that state to disclose and create policy approved by local government. The robots are part of that, drones are part of that. That makes sense to us because that applies to all technologies or all types of technologies. But to single out robots specifically and say there's something especially risky, problematic, or dangerous about robots, so we're only going to require robots to go through the city council process, I think that's a little bit playing into the fears and science fiction of robots. And I worry, as I think both of you have discussed, that the lawmakers don't understand what the technologies do. And I appeared before the Los Angeles City Council at 2 hearings this year, and despite all the education and explanation over a period of 2.5 years on the question of whether LAPD should receive a donation of one of our robots, the profanity and the drama about what the robot might do or is going to do was so far removed from the facts that I worry that requiring that is going to result in the loss of a safety tool to the community. And I'm happy to talk, Cindy, with you about how the robots are actually being used in ways that do solve problems and protect people. So
I'm just going to ask you to wrap up just because we're at time.
You got it. So let me go back to one additional point. You talk about deployment decisions, and with reference to the NYPD experience of like a couple years ago. I think there was, you identified public scrutiny, and that's certainly true, but I think that alone doesn't necessarily warrant regulatory implementation. Like in that section on page 27, what is it about the robots in those deployments that was actually problematic? I'm sure there was an outcry that there was misunderstanding, there were viral social media videos, but I'd love to see identification. I think this would enhance your argument of what it is that the robots were doing in those scenarios that was actually harmful and problematic. Because from my perspective, those deployments made them provocative because they were visible, but they weren't actually problematic in substance in terms of community impact. So I think a little bit more discussion there would facilitate your argument. I have other comments that I'm happy to get to you later on. And one final thought is the vaccine and the FDIC, the sort of injury fund. Interesting, creative idea. I think those two examples, though, are a little bit inapposite, given that those are systemic risks. If you have people who reject vaccines, if you have people who lose confidence in their deposits being secure in a banking system, you've got national systemic risk. So those are the exceptions. We've set up this sort of fund that can help address people's concerns, because those are very specific risks. I don't think we have a robot system yet that would justify the kind of funding that you're proposing. And I think it wouldn't be tapped very often because the robots aren't presenting those risks. But again, happy to talk to you at length about this during the break and beyond, because I think it's so important. Thank you for the extra time here.
Okay.
Thank you. I'll just very, very briefly, thanks for all the comments, and I'd love to hear your follow-up. On the democratic authorization, just to be clear, we just think that any time police deploy technology that could infringe on people's civil rights and civil liberties, important policy choice that ought to be made by a legislative body. We definitely didn't mean a single robots out, and so one thing we need to do is go back in the paper and make sure we're not making it appear as though robots are unique. I think all of these surveillance technologies ought to be regulated and democratically authorized.
Thank you.
Thank you. All right, Jorge?
Hi, Jesse Wu, Columbia University. So I think I like the paper a lot. We talked about it earlier. My biggest critique is that, the overwhelming majority of police departments are funded and overseen at the local level, right? And there's really, like, you focus on state and a little bit, some federal efforts, but there's, as Brendan mentioned, like, there are a number of local initiatives in Seattle and in Seneca County that seek to bring democratic governance to police tools, especially surveillance tools, and a lot of these would actually cover the use cases that we're talking about for robots now, right? Drones, the night scope, which is essentially a camera on a Roomba, right? So I would like to see a lot more discussion of that. And in one of your, I would really love to see, potential, we talked about this a couple of years ago, right? The attaching requirements to federal funds for local police departments, right? Just a senator's office, that would really love for you to advocate for that. So there's, I think, just that, like, one, you need to recognize more like what the reality is in terms of police regulation, and there's just like a lot of work that we can talk about when we get to that. Very quickly, I think it'd be helpful, especially when you're talking about like this human-robot analogy, what level of autonomy are we really talking about here? Because right now, right, a person that's remote control flying a drone or just setting a destination for a drone, like, that's really not that much autonomy that we're giving the robot. And so is it really an agent? Like, do we need to apply the rules for a police officer to that? Or is it just a tool that they're using? And finally, since I don't see Ryan in line, the term you're looking for is a privacy catalyst. That's an old paper of this.
Thank you for the comments. And I'll just say briefly, that is a really intriguing possibility, the idea that we can somehow condition receipt of federal funds under, the JG programs or whatever it is, the BRIN program that I'm sure you're aware of. That's an intriguing possibility. We've really been focused on state and local, but that would be a really good conduit for federal action.
Okay. Thank you. Lorena?
Hi, Kristen Johnson from UBC. Thanks for a great start to the day. I would just share 3 things that sort of jumped out at me, and feel free to take them or leave them. The first is, I'm really curious, I think this builds off Nicholson's comment actually, I'm really curious to know or think more about how anthropomorphism comes into play with psychological detention when we actually think about the deployment of these robots. And I think it even connects with some of what Brendan was saying as well about it's not just how we would actually describe the robots, but also how they're interpreted by the people interacting. And then the other two questions are a little bit more of a step back from thinking about actual regulation, but you go through this cost-benefit type analysis, and the thing that jumped out to me was cost. So robots are expensive, training is expensive, insurance, training facilities, etc. I'm from Vancouver, where people are increasingly struggling and the police budget continues to grow and grow and grow. And I certainly have a sense as a person who pays attention to this that any excuse to grow a police budget will be adopted. And so I'm just curious in how that might relate to how we want to think about regulating these technologies. I know it doesn't fit in with what you're specifically proposing about regulation, but as sort of a meta issue, is that these are a very expensive acquisition, and police budgets already contain a lot of space and take away a lot from what a municipal budget could otherwise go to for technologies. So how might this actually proliferate that issue and potential municipal inequity? And then connected to that, this is also a bit more of a meta point, is because because robots are so expensive, what would the regulation around how people interact with those robots look like? And is that going to increase carcerality? Is that going to increase the criminal law response? Like if somebody attacks a police robot, are they now going to be criminalized for their response to the robot because it's such an expensive acquisition? Just some meta thoughts.
Thanks for the comments. That's really interesting. For whatever reason, we didn't go into the cost that much of robots in the paper. It's now obvious to me that we should, because some of them are very expensive. You're absolutely right. And one of the issues that we've been seeing is that police acquire these tools in various ways that get around democratic oversight. They have civil asset forfeiture funds, which they can use to buy the robots. They can get the robots from private donations, from foundations. All of this is to say that I think all of these ideas are connected, like the cost of it, how it's regulated, but then also whether there's sufficient oversight and accountability for those tools.
I'm going to, I just handed out numbers. So folks who are waiting in line who look very uncomfortable, and I don't want to make you like stand around uncomfortably, so feel free to sit down. We've got numbers and we're just going to go in order, okay? All right, so one is over here, odd numbers over here, so feel free to sit down until your number's up, and maybe that'll make us all a little more relaxed.
Very sensible solution.
Yeah.
My name's
Automation, structure, yeah.
I do AI ethics at BP. Meredith, we actually met before at the Royal Society.
I remember.
Launch, yeah.
Yes, thank you for coming.
You should definitely read it, it's really, really good.
Thank you.
My question is, essentially in the UK at least, right, we have the issue about increasing police budgets, but also in the background of austerity, the truth is, our institutions got gutted. So they often look to facial recognition or tech or AI solutions, almost as a desperate attempt of we need something that can scale and solve these problems because we're not getting the same amount of money that we used to be getting, right? So in light of that, if we were to have some sort of auditing procedures of how you introduce these technologies in the first place, should there be independent audit of policing institutions to justify why do you actually use this technology? Was it because you're secretly underfunded and you're kind of desperate to do something? But also, should we be considering new ethical risks as well, over-reliance on lots of skills? And if we're going to have this new auditing procedure, how could you apply this to private corporations that might want to have a security robot outside an office?
That's really interesting. So first of all, yes, I do think there needs to be scrutiny of why they're getting the robot. There's an interesting tension between these comments because on the one hand I'm concerned about cost, but then robots can maybe automate police tasks, right? And so then maybe you need fewer officers, or maybe you give officers fewer hours. But then we run into the de-skilling problem that you're identifying, which is that are police going to begin to lose valuable skills because they've over-automated their jobs? And that's to say nothing of police unions, how are they going to play a factor into all this? So that is a really interesting comment that I want to think about more. But I think to answer the main question, yeah, I think that is probably at play. It's certainly at play, in adoption of other technologies. We were talking about ALPRs earlier. Now that's a relatively inexpensive technology that can automate a lot of traffic enforcement. So the same thing might hold true for robots, and I think there are a lot of follow-on consequences from that.
Yeah. Probably a lot of people in mind.
All right, thank you. Okay, 2.
Paul Kevlin, representing myself. 2 points, one early, one quick one, dogs and horses and other police animals. You bring up dogs a lot in the paper. I think it would be interesting to hear more about how maybe regulating with the basis of the police animal rather than the police officer, since theoretically the robot is more obedient but also less harmed if something happens to it, so it is both less protected and the responsible officer is more responsible for what it does. The other one is public discourse versus bans, both of which were sort of brought up during the discussion. You talked about, I think, how the K5, the Nightscope K5 tended to, in some cases, cause more crimes than it solved, which seems like a great principle for a ban, since if it's causing more crime than it solves, not useful as a police tool. But on the public discourse side, its main sort of use case is to replace or augment in-place surveillance, or maybe even replace surveillance might even be better in a lot of cases. But the K5 is obvious surveillance. So maybe all those attacks on it are actually just the result of people becoming aware of just how surveilled they are, which they were going to be anyway even if the K5 wasn't there. So it might actually be enhancing the public discourse in people finding out what's happening.
Thank you. That's interesting. On the question of bans, and in a slightly different context, we were debating in the paper, should we just say ban all weapons? That's obviously like a place you would want to start. And part of the concern we've had, in part, I think in a lot of jurisdictions, they're just going to ban this altogether. They're going to ban the K5. They're going to ban the ability to put weapons on drones. I don't know if that's the case nationwide, and policing generally is regulated at the state and local levels. I do worry that bans end up creating a vacuum, and when eventually the technology is accepted or reintroduced, then you lack regulation. So, facial recognition bans were put in place, and especially in 2020, some of them have fallen by the wayside now. And I think there's a question to ask whether, in between the time they were banned and now, whether if smart policy were implemented from the outset, we might be further along. That's not to say that I think we ought to have facial recognition. I think that's an incredibly difficult issue. At least I think it is. But I take your point. I think we need to maybe do a little bit more to kind of capture that tension in the paper between bans and regulation.
Yeah, great. 3.
Hi, my name is Koprivcic. I'm a 3L at BU. My question concerns how do you address the issue of constitutional stagnancy that is kind of implicated in your remedy? The qualified immunity, one of the issues with that is that you don't have a huge of constitutional stagnancy because you don't reach the question of the merits on what constitutes reasonable force. That's why you have a clear, established rule. You really can't get to it because usually you have qualified immunity. I get the impulse of putting it to court of federal claims for like the vaccine program because that way at least you get like compensation for the victims. But that doesn't create any kind of standards for what is excessive force, which we already have an issue with in the context of qualified immunity. So how do you get around that problem where, especially if you concede, the baseline premise that we are using for force, which, I would say kind of going ban it, but assuming we do that, how do you address those issues of creating standards about reasonable use of force, especially when you're saying to a non-Supreme Court that can't really create precedent with that?
So I'll answer the second part first, which is that I think the answer here is there ought to be a statute. There ought to be a statute. We over-rely on the judiciary to solve these problems. And Fourth Amendment is not going to save us from our new, all these new technologies. On the first point, I think it's interesting because you can view the creation of legislation as an exercise in advancing constitutional norms. So you're right. The judiciary is a place. Well, actually, there have been a lot of constitutional evolutions as of late, but at least in the policing world, we don't really expect the court to kind of keep pace with technological change. But part of the point of legislation, civil rights legislation, is that we're trying to advance constitutional norms. We're trying to advance equality norms and other things located within the Constitution, even if they're not constitutional in nature. All which is to say that I think part of what we want to do is acknowledge that for various institutional reasons, courts are not fully vindicating people's rights. And but courts are not the only constitutional actors in our democracy. So are legislators, so are people in the executive branch, and they too have a really important role to play in enforcing constitutional norms.
Thank you.
Thanks. Max, I'm Woody Hartog from Boston University School of Law here, but I am actually not speaking in my own capacity, though I did love the paper, and I'd be happy to talk with you afterwards. I am speaking on behalf of our Sugog from Microsoft. I'm going to read what she sent me to say about this. So, my name is Sugog, and I work for Microsoft. I mean Microsoft. Please tell your co-authors I said hi. Barry and Farhan. I love this paper. It's so timely and well done. You get bonus points for finding a reason to drop an F-bomb in an academic paper. Chef's kiss. Okay, on to the feedback, which is all from my cat, Tatters Kitty Club. First, Tatters thinks police robots should look like cats. Cats never hunted slaves, and they might better signal the robot's unpredictability by modeling it after the most unpredictable creature of all. On a more serious note, Tatters wants to know if the police robots could help her get out of a sticky situation, like trapped in a tree or down in a hole. I told her the robots weren't necessarily great at fine motor skills like gently handling cats, which led us to discuss how police robots might accidentally hurt both cats and people when endeavoring to help them out. Tatters thought you might want to explain a bit about robots' physical limitations and differences versus human cops. Naturally, she wanted to know who she could sue if a robot cop hurt her, so I read her that part of the paper. Tatters applauded your creativity in suggesting something like the National Vaccine Injury Compensation Program, but she thinks that would only create incentives for the vendors, not the police. She wants you to think more about what could incentivize the police as well as vendors. The challenge is formidable, but this is your chance to go down and kiss Tori.
Well, thank you, and that's a very cool comment, I think, Sue. Yeah, no, I think that's right. The idea of a compensation fund would probably put more incentives on the vendor. One of the ideas that we had in the paper was, well, as part of the determination as to the premiums or the amount of tax the vendor pays, would you factor in like the amount of successful claims made against the vendor, which might induce the vendors to vet to whom they sell their products. But I think you're right, and this is a comment that Farhang made as well after we submitted the paper, which is that it feels like police don't have enough skin in the game, and that's certainly true even in policing outside of technology because of police indemnification. And so you end up with this funny thing where, the civil rights laws are premised on the idea that these financial penalties are going to deter this, behavior that we want to avoid. And in reality, they hardly ever. Gianna Schwartz has a paper in the NYU Law Review on this topic, finding that essentially they virtually never have to pay for the constitutional and physical torts that they inflict on people. So super interesting thought that I think we need to go into further depth about in the paper.
Okay, thank you.
Hi, I'm Michael from Penn University of Miami School of Law. This is a very useful and readable paper that you've heard a couple times already. I think the qualified immunity discussion is in many ways the most interesting and thought-provoking part. Maybe deserves a paper of its own. But I'm here to make a really picky, small lawyer point about a small thing you mentioned a couple of times, which actually has implications. The paper advocates more than once extending existing rules that apply to legacy police, the robot police, and then also obviously doing more as well. But why? At least at the constitutional level, and probably more generally, don't we automatically assume that the current rules must apply to the robotics, whether we call them agents or tools? After all, we have a lot of case law. If the sheriff says something, hey, will you go in the house and find the knife? That's clearly a search and need a warrant. I can't see why a robot with autonomy be any different. If people with autonomy can be agents that are caught by constitutional rules, why can't these? And you seem to assume otherwise. I'd love to know why, because I couldn't figure it out. So that was all I said.
That is a terrific comment. As you say that, I'm not sure why we've seen that either. You're absolutely right. I think this is an interesting research question. I don't know, and I think we began to look into, you brought up the idea of, well, if a sheriff has an agent, but then there might be the distinction between like an agent and like a non-human tool of some kind. And then there's sort of so I wonder whether you would, because this is not an area that we researched, but do you think that a different rule would apply to a tool like a robot versus an agent?
Kylo for sense and hand searching, but maybe, but probably you don't want to push the law that way. You want to say agent tool, plug in a comma, and then we have at least that floor we debate where we should move the law to. You seem to be conceding too much.
I think it's perfectly fair. Again, it's something that we hadn't thought about, and it's super interesting. Again, it's still like difficult because Kylo, it was a human operating the thing, and so there's a sense in which we're talking about a tool. There's also a sense in which we're talking about a person. But in any event, this is super interesting.
They didn't go into the house, so was it?
Right. They were outside. Yep. But that's super interesting. Thank you.
Thank you. All right, Sexy.
Hi, I'm Franny Choi. I teach I'm faculty in literature at Bennington College and teach classes in Asian American Studies and speculative literature. But for the first 10 years, I'm going to just not use this, I'm just going to figure it out. For the first 10 or so years of my professional life, I worked as a community organizer, mostly working in policing in Providence, Rhode Island. And so, this is hitting home in a lot of ways. Having worked for years with the communities that did face over policing. I think that I have a very tiny piece of feedback and a kind of meta piece of feedback. The first is that in your benefits section around, specifically around use of force, potential benefits, there was this note that deploying use of force remotely might allow police to deploy that force more judiciously. And I know that later in the paper, in the risk section, you kind of counteract that claim, but I wonder about the kind of like responsibility around making that claim, the benefit claim, kind of unqualified, even if it is counter, just because of this seems sort of like the highest stakes part of it, and so I found myself really fighting with it, given the kind of robustness of evidence that is not true. That deploying force remotely does not, in fact, allow people to make that force more judiciously. So that's like my tiny feedback. And then my larger piece of feedback is kind of connecting back to something that somebody said about speculative fiction and the way that we might look to sci-fi for solutions. I'm really intrigued by the novelty of the kind of comparison to the Vaccine Compensation Fund. I think my feedback is really just to continue to look to community solutions kind of coming out of the communities that are facing this over-policing, because in my experience, those are some of the most innovative, novel, and wild solutions that I've ever heard. So I would just, my feedback is just to encourage you to look both to literature, to artists, and then also to communities that are facing over-policing.
I appreciate that.
Max, I'm really sorry I jumped in here. We're running pretty significantly over time, so if we could just get one quick lightning answer, and then we'll wrap it up so that we can get on to the next panel. Thank you very much. I apologize.
Okay, we have just two more people in the queue.
Okay.
Yeah.
Excellent.
Okay, yeah, I'll be quick. Well, in the discussion, we talked a little bit about, like, can we look outside of regulation, different stages, and like, oh, they're here. And so there's a lot of conversations in human-robot interaction, both on the side of, like, we should not be designing these systems, and then other people saying, well, if we don't work with the police to design these systems, they will be worse. And so I think that's an interesting, complex space to sort of think about and maybe take a stand in. Also, the other side of this is sometimes I feel like these robots are being used as a Band-Aid.
to really kind of challenge you to think on deeper like structural change level. If we put regulation in place, will it give us the time and the space for us to really think about how do we redefine policing and deal with all the trauma and the issues surrounding it. So I think that would be a really great thing to kind of consider into like, how is this technology being used just to scrape things under the rug?
Yep, absolutely. I agree with that, and that's something we want to address for sure.
Thank you. And then I think we have our last commenter.
I'll try to make this quick. I think, a lot of the police shootings that have been in the news have involved cases where police are afraid about their own lives and they're reacting on the spur of the moment, sometimes based on inadequate perceptions of the risk, based on all sorts of biases. It seems that a robot could avoid all those problems. A robot could take more time, think about the matter, not react quickly and out of fear. And so given that, I guess I'd be reluctant to have a policy of, for example, banning the use of robots by police. I'd be reluctant to have a policy of disarming robots. It seems to me that you can actually save a lot of lives, and a lot of the problems that you're seeing in poor communities with police shooting people quickly, you maybe solve or avoid or lessen through the use of robots. So I think that's something that it strikes me, at least preliminarily, as a very positive feature. I'll leave it at that.
Thank you, and I think, just all the diversity of opinions in this room just goes to show that this is a really difficult question of values. It's essentially a policy judgment, and this is exactly why we need democratically accountable people making the decisions whether to deploy these tools and how to regulate them, and not put it just in the hands of unaccountable policing agencies.
Okay, let's applaud our
So I'm Nicholson Price from the University of Michigan Law School, and my delightful, fabulous authors are
Igor Vuletic from Osijek, University of Osijek, Faculty of Law, Chair of Criminal Law.
And I'm Jan Koprivcic, I'm a general trauma surgeon from Osijek University Hospital.
All right, great. So this is a super fun, interesting.
The microphones, that would really help.
Okay, perfect. Yes.
Thank you.
Should we go again? No, we'll go with it from here, right? Yes, it's useful to hold it. Great, perfect. So this is a super fun paper written by a pair of a surgeon and a lawyer, bringing insights from both fields. Delightful strengths. So this is a paper that is comparative, but not along just like, hey, let's do Europe versus the US, because that assumes that Europe is a monolith, which it's obviously not, and gets into the wonderfully messy differences among at least a few exemplars of European law, thinking about I should say what the paper is about. This is about criminal liability for autonomous surgical robots. So we've got Croatian and German and a little bit of Slovenian law reminding us of the wonderful messiness going on here. So I want to start just a little bit, because I think we'll turn back to this, to address the taxonomy that they use for what types of robots they're thinking of, which will end up mattering. So they borrow a taxonomy from Yip and Das, where we have kind of the lowest level. This is robots where there's direct control of the robot, so kind of just extension of the surgeon's hands. Then we go up one level to 2, which is shared control. Think about this as surgical robots that are doing things like correcting for tremors. One more step, we have supervised autonomy, where there's a human who is ordering the robot to do things and then overseeing it the entire time and watching over it the whole time. And then last, at the level of kind of level 4, full autonomy, where we have, and I'm going to quote this because I think it's important, the robot fully and autonomously plans and carries out the surgical operation by extracting the necessary information from data related to the specific patient, i.e. test results. And this is the ultimate goal of the healthcare industry. So we're talking about robots that are really autonomous, actually planning, making the decision, executing the decision in the context of surgery. So the rest of the paper focuses exclusively on this, so I'm going to focus on that for now, although I'll then take a step back when I turn to my own comments. So, fun thoughts from a surgeon about what it is to do surgery right, what it means to do surgery well, why robots are going to fail at this, in part because what it means to do surgery right is not just to be skilled, but also to be intuitive and emotional and human. And by definition, robots are going to fail at that second part of the process. And then we turn to the lawyer, and I freak out because it's about criminal law for health care, and I'm like, I don't know anything about criminal law for health care, and I'm totally terrified that this is going to be completely different, and I have no idea what's going on, except that it turns out that conveniently enough, the way you do criminal law for medical malpractice seems to be quite similar to the way you do negligence law for medical malpractice, which is to say, with a little bit of dancing around and a little bit of change, but basically like, hey, did the person doing the thing fall below the standard of care? And did it cause the injury? And was that a predictable cause? And so I'm like, yes, Paul's graph. We're back in Paul's graph land. This is exciting. I know what I'm doing here. I taught torts once, so I can knit. Great, perfect. So then the argument, I think, is roughly a three-part argument in the law as to how this shakes out, right? Standard of care. Well, you've got to fall below the standard of care for liability, but the authors proposed robots will be programmed with the standard of care and therefore, essentially by definition, will never fall below the standard of care, which they say is a problem, because if you don't fall below the standard of care but patients get injured, well, how are we going to find liability? How are we going to find some ability to get patient or punish the wrongdoer or get patients redress, although that seems to be more torty than criminally. But how will we find some way to redress this wrong? Then we turn to causation and say, well, if the robot's making its own decisions, don't we have a break in the causal chain there? Right? Because we no longer have an individual who's controlling it, and so how can we get back to an individual past the robot? And then third, predictability, yay, Paul's graph. If a robot learns from its environment, develops its skills, learns from its data, makes decisions, how is that predictable enough to find the causation and the predictability necessary for criminal liability? So as a result, they conclude patients can't get effective legal protection from malpractice based on the criminal law, at least in these jurisdictions in Europe, from autonomous surgical robots, and that's bad. And so this is a fun, provocative article. It's rich in detail. There are so many cases described, both cases from medical malpractice law, from the law of robots, and from the author's own experience. Before I go on, have I done anything crazily wrong summarizing this? All right, cool, awesome, great. So my thoughts. I want to first make a broader point, then I'm going to fight the hypo. Then I'll give in to the hypo and assume that it's right and talk about that, and then I'll give in a little bit more and then fight some assumptions around the world, just so you know what's coming. So I think my broadest point is I'd love to see more about what it means to be talking about criminal liability here. Right? It's so fun. Like, we're talking about crime, and that's different from tort. When I think about this stuff from the tort perspective, I'm like, yeah, incentives and compensation and deterrence. And like, criminal law does different stuff. It makes sense to think about incentives and deterrence and compensation if we're implementing a system of robots that are going to do stuff and like improve care. But here we're talking about crime and punishment and justice. And I'd love to see you lean into like, what does that mean differently? I recognize that that's the baseline that you're operating from, because that's what it's like in Croatia and what it's like in Germany. There's crime going on for medical malpractice. But what does that mean differently when we take it for robots? So I'd love to see a little bit more about that. And of course, there's a rich literature that addresses this outside the context of surgical robots. I'm here thinking of things like Galasso and Luo talking about punishing robots and how that affects incentives for innovation, about Lemley and Casey talking about remedies for robots and incentives for change. I'm thinking about Christina Mulligan's paper on revenge against robots. And I'm thinking about Abbott and Sarch on punishing robots for criminal liability in particular. There's stuff here to lean into. All right, so fighting the hypo, point about autonomy. I think you'd lean into level 4 autonomy. These are robots that are taking in information, making, planning, executing, and I think it's a super fun hypo. I also think we're a long way from that. And I mean, like, I'm a science fiction guy, and even with Star Trek, you have to go past the next generation to get to that. Like, sure, you go to Voyager, and we've got a robot AI doctor who's doing stuff, but even in 23, 34, whatever the next generation is, they've still just got Dr. Crusher doing the things, and the AI is helping out a lot. So we're a ways from that. And there's a lot that seems to depend on this. But it seems like if you go even a half step back, not to step 3, but to step 3.5, and you say, well, what if we have a robot that's carrying something out, but we have a human who's making the order, and then if something happens, then the robot says, hey, what should I do next? And the human says, oh, do that. Like, even if we step back just a little bit, then a lot of these issues, at least at first glance, seem like they go away. And so what does that mean? And how much of the analysis here depends on a hypo which is fairly far away? But I'll stop fighting the hypo. Well, actually, sorry, one last thing about that, which is if we assume lower levels of autonomy, of course, I don't want to suggest that once we have more human-robotic interaction, everything goes away, all the problems go away. We just get new and exciting and different problems as all the human-computer and human-robot interaction people in the room can tell us lots about. All right, but stopping fighting the hypo, if we assume that the robot is not acting under the standard of care, if they're not falling below the standard of care because by hypothesis they've been programmed with it and so they do it, I guess I'm not sure why we care if a patient gets injured. I mean, it's a bummer, don't get me wrong, like patients being injured, that's sad. But and certainly in medical malpractice law, if the doctor's doing everything right, if they're following the standard of care and the patient's injured, we don't find any liability for them, either under a civil system or a criminal system. And so why is it the case that if the robot is doing everything that the doctor would otherwise do because they're programmed to do it, why would we be particularly bothered if a patient gets injured, at least if bothered in a legal sense? Now, we might say we should treat robots differently, and indeed we talk lots about how we treat robots differently, and we might talk about, well, how should the standard of care change once we have robots programmed with the human standard of care? And if they're learning, does that mean we change the standard of care for robots? And if that happens, do we then go back and change the standard of care for humans and say, well, actually, no, humans shouldn't be doing this anyway because robots are doing it better? But that's a whole long path down. And I'd love to see just a little bit more chat about what is it, why do we think we need to punish robots for doing exactly what we say that's what you should do if you're the human surgeon? And then I think the last question, stepping back again, leaning into the hypo even more, and turning to a baseline question, I think there are lots of assumptions here about how good humans are, which is lovely. And I'm delighted by the fact that as a surgeon on the team, you write, and what you see around you is your colleagues, and you see colleagues who are professional and skilled and empathetic and intuitive and emotional, and that's wonderful. And I think that is a wonderful standard. I think it's also the case that most people don't have access to human care of that level, and so if we think that the standard that we're setting is the standard of you have to truly be excellent and intuitive and emotional and human caring, what does that tell us about access to care potentially promised through technologies like this? All right, I'm at my 10 minutes, so I'm going to stop and look forward to your questions after a response from the authors on this super fun paper.
Thank you. Can you hear me? Okay, so thank you very much for this wonderful overview. You really got the point. Oh, I mean, we wouldn't do it better, even ourselves. So we wrote this paper from perspective of European law, continental European law, because we knew that it will sound provocative in circumstances of US law. Because I know that here criminal liability for malpractice is something very uncommon, unusual, something very rare, but it is not the case in Europe, at least not in continental part. I'm talking in terms of, I don't know, former Yugoslavia countries, Hungary, Germany, Austria, so there are many criminal cases actually going there, and of course there is a huge difference between that and civil claim, because as a consequence of a criminal case you can actually go to prison, and that happens a lot. And it is actually being problematized a lot, not only in science, in academia, but also in general public, especially in Croatia. So we have certain initiatives to cancel criminal liability, but that just won't happen because healthcare sector is a public one. And at least in our country and countries surrounding us, so there's always public interest emphasized, so the logic of thinking is a bit different than in the United States, where healthcare is mostly private sector, as I understand. How to punish a robot? That's a challenging question, and a lot has been written about it during the last couple of years, but at least to my knowledge, none of those papers gave any specific, concrete, actual answer to that dilemma. So is it possible to actually punish a robot? I don't think it's possible. So if, and now there is a practical issue. I'm going to speak from perspective of creation law, but it's similar elsewhere. If you cannot prove criminal liability, that often affects also civil liability. So it affects the right of a patient, or we can call patient victim, I don't know, right of patient to get a proper restitution and etc. So it is not only theoretical, but it is also important practical question, at least in terms of creation law. Our paper, that's true, our paper is based on the presumption that the level 4 of automatization will happen. Because I agree with you, first 3 levels actually don't create any, at least not any legal problem. I mean, we mostly have that covered. Maybe there will be some challenges regarding causality, causal nexus, but I think we got that covered. But if level 4 actually becomes a reality, then I think we are not covered no longer. So the paper is based on assumption that something will happen in the future, and maybe that's not such a long shot if you consider the level of autonomization in general in weapon industry, in car driving industry. So it's possible, but at this point it is based on something which still didn't happen. I agree with that, but we cannot escape from that. As for standard of care, our position here, my colleague will be able to say more about it, but our position is that standard of care cannot be always defined or programmed in advance to cure somebody, to perform an operation on somebody. Is a living tissue. It's like a football match. You can agree the tactics at the beginning, but then you have to change. You need to take an individual approach, and to do that you need to have experience. You need to have intuition. You need to have a feeling of personal feeling on ethics, on necessity, on maybe a situation where you need to sacrifice something in order to achieve something else which is more important. So you need to have this human component, I would say. Maybe if you want to add something.
So as my friend said, in surgery generally 2 and 2 is never 4. Although most of our operations tend to be similar to one another, there's always a percentage where there's something different. And if you do all the stuff by the book, you might as well hurt the person more than if you do it otherwise differently. In some way that you at that stage think that it's fine, but somebody else would in a different time think that it's not even normal. So we had numerous cases, not numerous, couple of cases of that, which it stays in the paper. With a gunshot neck injury, where the artery was ligated, and nowadays it's big no. You wouldn't do that. You would just call a vascular surgeon and fix it. But in those days, it was just a thing that you had to do for a person to maybe survive, and it did. So I think that this small percentage of moments that can occur during the operation is something that's on human to decide and to do, not on a program.
And it should stay this way. That's the position.
All right, well, let's open it up to questions, and I look forward to discussion. Yeah, go ahead.
Hi, Michael from Penn University of Miami School of Law. Like Nicholson, this was just a wonderful eye-opening read for someone like me who has written not as much as him, but some about the medical issues. I love the interdisciplinary collaboration, which is We Robot at its best. But you need, I think, to go to the next level and bring in an AI or roboticist person. Because the discussion of the AI capabilities and failure modes isn't as finely nuanced as the rest of the paper. So you say, for example, at one point as an example, that maybe programmers will be able to feed the robot all of the data related to actual professional standards. There's no chance in the foreseeable future. We have a wonderful early We Robot paper by Lisa Shea, Woody, and others, where they just tried to program the rules for traffic tickets for speeding and describe how incredibly hard that was. So I think, it's really easy to leap with an imagination in this, in the Star Trek world, but from here to there, it's a very long leap. So I think, therefore, I would say you cannot say with much confidence that we'll get at any time in the foreseeable future with current technologies to a robot that is guaranteed not to breach professional standards unless it just stays home. And, really the choices are always going to be tuning the models, type 1, type 2, there's an amazing range of choices, ethical problems at that level. You just move an ethical problem somewhere else, but you're not taking them off the table. So it's particularly shocking to read at one point. It was difficult to imagine current treatment by AI sufficient to be a crime, because I can imagine it all too easily. Now, conversely, this will seem contradictory, but I think it's not. The view of the surgeon as the intuitive decision maker under uncertainty. The surgery will I just had a surgery. 8 hours on the table, most of it came out okay except my leg. I was very happy that I didn't do it, it was great, but you say with confidence that the robot will never be able to match that. I don't know. The whole idea behind deep learning is you throw enough data into the pot about how people do stuff, you get an algorithm that does a fairly decent job of doing the stuff. And what's more, it does the stuff that produces good outcomes, if we don't know why. At least we can test for that. So it seems to me that, well, your analysis is surely right for a more limited robot that just does suturing. It's not obviously right for foreseeable technologies. And that's why you need the AI robotics, which is more about it than I do. And the last thing is, there's an elephant that belongs in the room, and that is the stuff in the upcoming panel on the EU AI directives. I'd really like to know how that meshes with everything you're talking about. I think I know, but the EU, I'm never sure I know. So somebody needs to tell me, because I'm not good enough to figure it out myself.
Okay, should we?
If you'd like to respond in brief, go for it.
Yeah, as you already pointed, it's not realistic at this moment, but maybe, I don't know, 15, 20 years ago it was not realistic that AI will even take over so much stuff as it does today. So I wouldn't be so convinced that it won't happen, I don't know, during mine or his work age before we retire. But anyway, at the present point, I agree with you at the present point. But the only way to write this paper was to to project something which might be happening in the future. As for the comparison between human surgeon and robot, I think okay.
You mentioned about input algorithms for robots. There's always 1% of cases in the world of something that you can't predict, and you can't always put all the data inside. So you just can't do that. For instance, just a couple of weeks ago, I myself performed the surgery on a person that I needed to implant arm implant into the leg. And you can't predict that up until you come to surgery itself. And then I think that there would be enough time for robot to be programmed in to do that. So I think that there will always be a need for in time thinking and changing the course of surgery. That's at least what I think.
And as for EU directive and EU law in general, in terms of supranational law, of course, I mean the purpose of EU law is primarily to cover private law, consumers law, and things like that. Criminal law is something which stays, I wouldn't say completely off limits, but it's difficult to harmonize criminal law. So EU directive will never be so precise to solve the problem, considering that criminal law traditions differ very much from country to country in 27 member states. So the existing EU AI Act is not giving us any solution in that area. It classifies the risky use of AI, but I think this is only this is very general. It's like a book of principles, I would say. But thank you for your remarks. Okay.
Hello, so I'm Andrea Bertolini, I'm professor of private law at Sant'Anna University in Pisa. So I don't really understand the concern of eliminating criminal medical liability. Actually, that would be the dream scenario. I think like criminal medical liability is one of the biggest problems we have today, and I'm European myself, and in Europe, in Italy, for instance, we have adopted regulation back in 2017 that was primarily attempting to radically shield medical professionals from criminal liability, because criminal liability and civil liability should be completely disentangled in the sense that one thing is providing compensation, and I'm always in favor of providing compensation. It is also true that back in Europe we have good welfare systems, so there's not that people would be paying for their medical care themselves. So we have a more limited need for compensation. But civil liability is one thing, and it's a good thing, and favoring the compensation of a potential victim or harm party, that's always good. To the contrary, criminal liability is one of the major concerns that leads to defensive medicine scenarios and all the like. So if it's true, but I do not agree with you, that an introduction of AI would eliminate or eradicate the possibility of holding somebody criminally liable, that would be a dream scenario. But I think it's unrealistic, like a level 4 automation in surgery. At the same time, I think that actually, if we take reality into account, and I think Professor Fromkin was referring to the AI liability directive. Now, the AI liability directive that radically addresses civil liability doesn't touch upon criminal liability. Is going to make a mess. I don't know if we will ever pass a piece of legislation, but it's probably one of the worst pieces of legislation that was ever written at European level. And I said it to all the members of the European Commission that I know and that I met in the last few months. I hope I have managed to persuade some of them to rethink it. But what I fear is that the current emerging regulatory framework on civil liability at European level is really going to put those medical professionals that do use artificial intelligence or robotics-related equipment in a worse position than those that do not, holding them to some extent more liable, strictly liable, and therefore that is going to not only really eradicate criminal liability, but actually increase the civil liability of medical professionals, discouraging the uptake of these technologies that otherwise would be very useful. So, if we made a more realistic assumption about the technology that we're taking into account and a more realistic assumption of the applicable legislation that we're taking into account, I think that the fear that would emerge is not that there is no way of punishing anyone, but there is that it's too easy to hold medical practitioners that use technologically advanced solutions liable as opposed to those that do not, based on European emerging legislation, which in a policy perspective is highly negative and something that we should radically oppose. If we instead manage to eradicate criminal liability of the medical professional because he uses AI, that would really be a dream scenario. But I think we're moving exactly in the opposite direction, back in the old continent.
Thank you for the comment. I might just add, we have had and still have a huge discussion, huge debate whether to cancel completely medical malpractice as a criminal offense. Healthcare chamber is strongly arguing for that, and one of the arguments is that it is impossible. Defensive medicine and other negative effects of that are making impossible to work and actually do more harm than good for patients' health. I mean, I doubt that will happen. I think the criminal offense will stick. But I already add that every profession which involves possibility of some dangerous consequences, let's say construction, driving, I don't know, it involves also a possibility of criminal liability. So I think it's something which is in I would say maybe tradition of continental Europe. So that's something we need to accept. Maybe if you want to add your opinion on criminal liability as a physician.
I concur with you. All right, before we get our next question, I want to ask, we're going to have an audience participation moment. All right, this is a thing that's going to happen. I would like everyone to stand up. Yeah, oh, yeah. I'm serious. Stand up if you're able. Yeah, you too. Okay, perfect. All right, turn to your left. Wait, nope, that's left. Turn to your left. Turn to your right. All right, great. You can sit back down now, but I'm going to encourage you, before you sit back down, to think about the fact that you're already standing, so it's really easy to go and get in the queue, because you're now awake. I've made you stand up. You've been sitting for an hour and a half, but like now's the time to be like, yes, I am back into this. I am roboting so hard right now. Now, our next question, and I'm not kidding.
I guess I shouldn't be surprised I'm not the only person who got up on his hind legs about the word never showing up in a paper about technology. Always a bit of a fighting word. But I did want to get a better idea of the sort of depth of the background of that, of the opinions that sort of together that a machine intelligence is categorically incapable or categorically not suited to making medical decisions on its own, and categorically not suited to the human ethics of medicine. And is this because it's inherently deterministic no matter how much random variables you inject, and so cannot react fast enough in that particular environment, and cannot make decisions which are fuzzy enough for the ethics of it? Or is it because there's something metaphysically unsuited about the probabilities in an AI versus the intuition of a human?
Yeah, that's the reason. I think that we shouldn't have a level 4 doing the surgery on their own, because there's always going to need to be a need for a human decision at some stage. So say maybe 90% of surgery can be done by a robot, but there's always that 5% that's different than from something that's usual, and that could be deathful to somebody, and that could be a problem at the end. So I think that's the reason that we shouldn't just let the machines do the job that we do at this stage, and that we should just intervene as much as we can, and just let the robots help us do our job as best as they can.
So I guess that brings me back to the baseline questions, which is that I mentioned at the end. So I think you have an assumption about the humans that are available to do the job. That I think your assumption is that the 95% of the time, cool, great, but the 5% of the time that the human that's there is going to do the job right, and we'll get a good answer. I guess my question is, how committed are you to that assumption? And if you relax it, does that change your view at a normative level? I'm guessing probably not at a positive level. It doesn't change your view of how Croatian criminal law will treat this, but does it change your view as to what the kind of right situation is if we assume away a little bit of the skill and empathy of the human physician that's the baseline that we're playing with?
I mean, if we assume that that human will not react.
Yeah, so I think right now you're assuming that there's a great physician.
Yeah.
Let's assume a good physician.
Okay, fair enough.
Like, how does that change the state of the world, and do we care?
Average physician. Okay.
Sure.
Okay, so let's start from the point that like most of us are just average physicians. That's something that goes with it. I think that
Mic isn't working.
isn't it?
Oh, you click the little button that turns it. Yeah, it's on. Here, you can take mine.
Okay. Can you hear me now? Okay. So I think that a surgeon is going to give his best at the stage where the robot will just do the thing he's programmed to do. So the robot will be programmed to do just that, and the surgeon, I think he will have an additional step up in the operation and way of thinking out of the box to do the job right. So I think that the robotic intelligence will be that it won't be able to make all the conclusions by itself, just by importing the algorithms. No matter how many of them you import them, there will always be one percentage, not one, just part of percentage that's going to need something that's out of the box thinking.
Is there anyone else?
Lunch.
All right, we are remarkably back on schedule. Thanks. Please join me in thanking our terrific authors.
So this panel, this dual presentation of papers, is not actually just about the EU AI Act. It is about the elements of the EU AI law package. So for those of you who don't have necessarily the context for this, the European Union is trying to pass an enormously ambitious collection of laws, a mix of hard law and soft law, regulations and directives that are aimed overall at harmonizing an EU approach to artificial intelligence. The EU AI Act is a central component of that package, but there's more. So that's important context for understanding these two pieces. I'm going to talk about both papers and then turn it over to the authors and co-authors to respond, and then turn it over to you. So start thinking now about what you want to say. And what I'm going to try to do in these discussions is to both summarize enough that those of you who may not have had a chance to read the entire papers can participate. So again, don't feel like that's a barrier to participation, while also offering some suggestions on how I think they might be rearranged. So the general purpose AI systems in the AI Act paper, which is by our co-authors, Claire Boine and David Rolnick on this side, is an interdisciplinary effort between a law PhD and a computer scientist to track the changing definition of AI in the not yet finalized EU AI Act. At its core, I think this is an enormously important contribution because in any regulatory system, you're going to start with a conversation about what the object of regulation is and how to define artificial intelligence. So this paper is specific to the public deployment of general purpose AI systems, which were not contemplated in the early definitions of early drafts of the AI Act. The core thesis, if I may, is that the EU AI Act was built around regulating risks of use in high-risk contexts. So for example, the use of AI in education, the use of AI in employment, the use of AI in law enforcement, and it largely is structured as targeting the developers of AI systems as though they develop a system with an intent for use in a particular context. General purpose AI, in contrast to this regulatory approach, is defined in the paper as general purpose tools that are adaptable to any context by the deployer of the system, and therefore is a poor fit for the EU AI Act, although the European Parliament in the latest draft before the trilogue has tried to shoehorn both foundation models and general purpose AI into the EU AI Act. All right, slightly more detail. The paper charts what I would say is a socio-legal history of the definition of AI, which has changed considerably over the course of the development of this regulation. I highly recommend for all of you who might be taking notes, the table on page 7
which charts the detailed changes in definition between the drafts. The change is characterized in the paper as a shift from an initial definition that emphasizes autonomy, or really defines AI systems as AI agents, to a second definition that focuses more broadly on AI as software or statistical tools based on large data sets, then back again to a definition of AI agents that focuses on autonomy. This is an intellectual history of sorts. It tracks the various news stories that the authors claim influenced the regulators, including the Compass story from ProPublica, the Cambridge Analytica narrative, and many others, which they point out are actually not about AI systems at all, but about large sets of statistical analysis of greater or lesser complexity. And the core claim of the paper is that this socio-legal development of a concept of AI in society has really pushed the development of the AI Act and the regulatory tools that Europe is choosing to use to apply to these systems. So some of the ways in which the authors claim that the definition drives the shape of the AI Act are as follows. They say, because these examples of statistical systems are really dependent on the context in which they're used, you see an AI Act that focuses on harm dependent exclusively on the context of use of the system. They say that even though the AI Act, this I think is super interesting, so I'm like this, even though the AI Act is all about regulation ex ante, meaning before the harm occurs and at scale, hi Woody, the harms in the AI Act are actually conceptualized as really individualized harms as opposed to societal level harms. So there's a mismatch in the AI Act between the shape of the regulation ex ante at scale and the harms that are being conceptualized as really fundamental rights harms at an individual level. And then finally they say that these stories, these narratives and news about these faulty statistical analyses coming from the use of large data sets created an overfocus in the AI Act on problematic data sets, which has a regulatory consequence of looking less at the places where the systems are deployed, particularly in hybrid settings where a human might introduce some sort of fault in human-in-the-loop systems. All right, so I will just say as a note, I think these individual analytical points are so important. I'm not convinced that there's a causal relationship there between the change in the definition and these features of the AI Act, and I'm going to explain why in a second. Now for suggestions. The paper is largely told as a chronological story. So it's like, this happened at this time, this happened at this time, this happened to the regulation, this happened if the regulation changed. And it's framed largely as being an issue of the pacing problem. Anybody know what the pacing problem is?
I know it.
Tell me what the pacing problem is. Let me read you the first sentence and then you can tell me why this is the pacing problem. At different points of time, authors of the legal doctrine have questioned whether the law could properly regulate new technology since it is inherently slow and conservative. Yeah.
Pretty good.
Yeah. So the thesis of the paper is that the AI Act is being driven by the conception of technology and that the technology is changing faster than the law. I don't like that. What I think is actually happening and what I'm really excited about in this paper, and I actually think you're 3/4 of the way to doing this, is that you've written a potentially foundational work on how the AI Act uses tools from legal analysis to legally construct the AI system in ways that are poor fits for general purpose AI. Okay, what's legal construction? It's this idea that Meg Jones named and a number of us have been practicing that basically, guys, that was not intended drama. That law, as a social and linguistic system, constructs the meaning of new technology and their uses with policy consequences. So if you're practicing legal construction, you look at the values, the institutions, the regulatory tools, the objects of regulation, and it's not merely a rhetorical project. To quote Meg, hi Meg, the way that we make sense of technologies changes the way that we design, integrate, and regulate them. So here's what I think you're actually doing, and this I think is a fantastic paper. You're showing that the EU AI Act is stitching together a particular version of risk regulation, which allocates regulatory resources based on perceived levels of risk, that's your buckets, and EU product safety law, which focuses on the intended purpose and fit for purpose, and that mix of legal tools doesn't work for general purpose AI. Okay. So now I'm going to turn, and I guess the comment I want to read out loud directly is, now that's a really interesting and crucially important paper, right? Okay, so turning to the second paper on AI liability in Europe, I'm going to back up again and give you some more regulatory context for those of you who might, again, be intimidated by European law as topic. So where the EU AI Act is the central component of this regulatory package on AI, it is, as I mentioned earlier, only one component. The EU is promulgating 3 legal initiatives. 1, the central harmonized framework of the Act. 2, a civil liability framework. And 3, a revision of sectoral safety legislation, including the thrilling machinery regulation. This next paper by Bia is about AI liability in Europe. And it explains, I think again at its core, the surprising ways in which the EU AI Act interacts with the 2 other parts of the regulatory package, civil liability under the AI Liability Directive and the revised Product Safety Directive. I learned a ton. So before I get into details, I want to again frame this piece of significance in a way that I think will also hopefully be helpful for you in revising it. A lot of pieces, I think this piece sort of gives us a red herring, which I think some of you may end up engaging with. There have been a lot of pieces that have written about tort liability in AI, right? About the so-called substitution effect in which a human actor is substituted with an AI, and that creates a whole host of complications using a complex, opaque, autonomous system for concepts of causality, duties of care, and fault finding. Initially, this piece looks like it's going to be one of those pieces. So the author talks about how AI systems are opaque, how they're complex, how they're autonomous and generative, and that these are features that, I'll put this in quotations because it's my word, not hers, that disrupt civil liability framing. What's actually happening here, I think is a lot more complex and interesting, is that there's a careful tracing that you do of the ways in which the risk regulation portion of the EU regulatory package interacts with and drifts over into the civil liability framework in ways that like damp down the potential of revised civil liability to do any good in this space. So backing up to significance, the EU AI Act is largely, again, ex-ante risk regulation at scale, I would. And one of the major criticisms of the EU AI Act has been that it fails to provide adequate recourse and redress for individual harms, specifically fundamental right harms, but just harms all the way down. Because if you create these risk buckets and you start regulating ex-ante at scale, then when actual harms happen, you're not leaving a lot of space for individuals to get either recourse to justice or redress. The second thing, there are many things the EU AI Act has been criticized on, but I'm going to talk about 3. The second thing the EU AI Act has been criticized for is the way that it constructs the AI supply chain, and that, as I mentioned earlier, it focuses predominantly on regulating the developers of AI as opposed to the users of AI. And it focuses largely on data sets, not deployment, which means you don't have particularly effective regulation, at least on paper, of humans in the loop, of hybrid human-computer systems. The third thing it's been criticized for, we saw some of this in the previous paper, are the cliff effects of its regulatory buckets, where if you have a risk regulation system that's based on saying some things create an unacceptable risk, some things create a high risk, some things create low risk, and some things create no risk, then when there are harms that arise from low risk systems, you're not regulating them. Right? You're sort of creating regulatory efficiency, going after the high risks, but you're pretending away the harms that might come from a lower risk system. So the core question that this paper really seeks to address is not, is tort law disrupted by AI systems? It's, is the civil liability framework in the EU regulatory package a good enough complement to the AI Act's risk and safety regulation to mitigate those 3 problems? The answer is pretty clearly no. And the reason that Bea gives is because, I think this is the detail work, is because the civil liability framework is too closely enmeshed with the risk regulation framework in the AI Act itself. I think in the interest of time, I'm going to skip over my details and get back to you on those. And just to give a little bit of the observations and comments, as you learned in my discussion of the first paper, I really don't like the tech driving law framing. I would start with the law first and explain why the particular features of the technology are important to the legal analysis and the ways that it attempts to get around them. I would trim the tort aspects of this paper a lot and or put them later in the paper, and maybe read and cite some of the US literature. Last thing I'll say, just as a point, bring this up in discussion too, is that for a piece that's addressing harms to fundamental rights, you don't get to the fundamental rights aspects until page 64. That's harmless. Yeah. Okay, so, but the overall impact of this piece I think is crucially important. It's asking, in the EU, has the EU built an effective complementary regime of civil liability and risk regulation? The answer is no. Hugely important for US conversations where we haven't even started really the initial scratching the surface of what this kind of complementary system might look like. All right, so now I'm going to turn over to the authors to respond at whatever length you deem appropriate. And then I encourage each of you to come up to the microphones to start having questions. Would you like to go first?
I mean, I don't have much to say. I love your feedback. I kind of patched the pacing problem onto this because, as you said, I was viewing this as a chronological problem. I know that's time problem.
Yeah.
But I actually I like your framing much more, and in fact, it's probably closer to what I think and how I view how I view most legal issues. So, yeah, I'll definitely reframe it. I think this is a terrific piece of feedback. Thank you. Do you want me to say anything?
I don't think we need to add anything right now. I guess maybe a slight point. I really appreciate your feedback and thoughts on the framing of the work. I would just note that from the computer science side, I think that there is not just a pacing problem in respect to the law conceiving of new technologies before they occur, but technologists conceiving of new technologies before they occur. Like, as a computer scientist, many of these functionalities were not conceived of before they existed. And some of the properties of systems that we are seeing are slightly more than people thought might occur. Not in the sense of we're getting sentience or consciousness or anything that is overhyped like that, but it is slightly more possible to have general purpose AI systems than have been previously conceived within the computer science circles. So this is not necessarily just a situation of gaps between, I don't think it's a situation of gaps between technology and law so much as it is just a changing situation as well.
Thank you. This was terrific feedback, and if you can send us that later, that would be super useful. I think I actually really like the framing of the question that you say I'm answering. Is the civil liability framework a good enough complement to address the criticisms of the AI Act? I think the only way in which I would temper the way you frame my maybe pessimistic portrayal here is that one of the things I've been thinking since is if maybe I'm just asking too much from the liability framework. And one of the things that would be an easy way to decouple both directives is to give a little bit more power actually to judges and decouple some of the, for those of you who are not experts in EU liability law or AI liability law, a lot of the things that these directives are doing are giving plaintiffs of these cases the right to require documentation from AI systems in court. So it's largely an evidence disclosure and a lot of regulation. And a lot of my argument is that it will only be high-risk systems, the ones that will have produced regulation, that documentation at extent. So if you have something that causes a harm but it's opaque and the documentation is bad, you're still pretty much not going to do great in court most likely. So I think a lot of, but that power only exists for providers of, in the case where it's a high-risk system. So I think a lot of that decoupling isn't a very hard thing to do. And then it is actually just the way the Europeans are doing it. It's a product safety regulation. It has an administrative law side of it at its core, and the civil liability part of plaintiffs just maybe will be smaller than I would have liked, but maybe
Yeah.
that's what liability law is.
Yeah, I think I can go into slightly more detail of some of the other great observations you make. That observation, so this, like, anybody here who's a US legal scholar who's trying to think of, how do we fit together ex ante regulation and ex post liability, these are just really interesting examples of how one might do it, whether good or bad. So as Beatriz said, the regulatory part of this requires tons of documentation and ex ante impact assessments and writing down when you have incidents, etc. The liability part of this says we're going to make that easily discoverable. The gap that she uncovers is that that documentation is only required for high-risk systems, which are only very specific use contexts. So you're solving the information asymmetry problem or the opacity problem, or at least you're shifting costs in that, but only for a very smallish category of systems. You're not getting it to everybody. The other one I wanted to raise, just because Nicholson's line and also like this is our paper, is the human in the loop stuff in this paper. So as she noticed, the central problem about the human in the loop and liability is that, and we've talked about many We-Robot conferences before this, is that the human becomes the moral crumple zone, the legal crumple zone, where the human operator is the one who might not actually be effective, might not be well enough informed, but is going to be the one who shoulders the liability because it's easier to see them, right? And so this is going to be complicated, but I'm going to try to do it. So she says that on the one hand, the AI Act in its current draft does a pretty significantly okay job of talking about humans in the loop and how much you have to empower them. And the AI Liability Directive has the potential to enforce those requirements, this is very in the weeds, but like so one of the questions about the AI Act was how are you going to enforce the human in the loop requirements? This potentially is like a hammer. But on the con, the AI Act the AI Liability Directive excludes from civil liability AI advisor systems. So any place where you have significant human involvement in the decision making, like the GDPR standard, the Liability Directive excludes that from its coverage. And that's messed up because basically it completely negates the coverage of any system that we care about. Because if you're a high-risk developer of a high-risk AI system, you have to have an effective human in the loop. And if you have an effective human in the loop, you won't be covered by the AI Liability Directive. Like that's a really important giant loophole that I think, like that could be a paper in itself. And then last, there's you note with the human in the loop stuff that there's a loophole in the AI Liability Directive that says that no developer or deployer is liable for decisions that are made to comply with existing law. So this is the link between regulation and liability. If the regulation ends up through standard setting or whatever, having a really ineffective definition of human in the loop, then your deployer of AI, where it fails, can say, you can't sue me for designing a bad handoff system because I've been in compliance with the EU AI Act, and therefore, I'm just in compliance with the law. Okay, Nicholson.
So these are both super fun. I have one question for each. So my question about the liability paper, I will confess I did not. Yeah, I'm sorry.
No,
so you might have already answered this. And if you did, you can just tell me and I will slink back to my seat in shame. How squishy are the cliffs? Sorry, that's a weird metaphor. So like these buckets of high risk versus lower risk, and the fact that disclosure is titrated to these being in which bucket you're finding yourself in. I'm curious as to how sharply defined the definitions are and how arguable they are, and what are the consequences of getting that definition wrong. So you can imagine if the situation is, if I'm on the edge between high risk and low risk, or high risk and medium risk, I'd rather call myself medium risk, but maybe I should disclose anyway just to be sure. Or is it the case that that's not a problem, and so like what are the incentives for people to think about themselves as one bucket or the other? I think I remember seeing on some, Mastodon maybe, that people get to self-certify the most recent draft which bucket they fall into, which seems real dumb, but I'm curious as to like how you play through that and how you think this is going to have impacts. On the other paper, I'm curious about, and man, this is just delving into all sorts of areas I don't know about. Do you think that there is likely to be a definitional legal construction Brussels effect. Which is to say, like, we're certainly bad at defining AI here. We haven't made any efforts at all, and I'm very excited for you to write this paper so that I can assign it to my class and say, hey, look, here are a bunch of efforts to define AI. What do you think? Why are they all wrong? But like, and I know there's a Brussels effect for all sorts of regulation and tort stuff. Is there going to be a legal construction definitional effect? Is what we think of as AI, either legally or technologically, likely to be worldwide based on what the AI Act is doing, like in this definitional section? Is that going to propagate? So those are my questions.
Do you want to answer first? Go for
Sure, both
Yeah, so it's actually pretty the opposite. So if you look at the, for instance, the definition foundation model in the AI Act, it's from that Stanford paper, you know, the big foundation.
They just took it from that paper.
Yeah, they literally just took it from that paper. The general purpose AI systems was taken from the paper I wrote, actually.
Oh, all right.
So I also know how that happened. Yeah.
So sorry, go ahead.
And for the definition of AI, it's fascinating because it's been the opposite, where by the time the AI Act definition came out, people were saying, oh, that doesn't fit the latest systems. And so the OECD published a revised version of AI, of the definition of AI, where they were trying to avoid the mistakes of the EU. And so it's actually been kind of, the EU has been informed a lot by what's been happening on this side of the ocean.
Can I just do I want to let you answer your question too, but super quick response to that. One of the questions I have in here is how did you choose the particular stories of influence over the definition in this piece? Because all the stuff you said I think is correct and super interesting, and it's not in the piece. So you don't talk about, this is a cut and paste of the OECD definition, or that this is a cut and paste of, I think you're saying Lemley's paper, yeah? That's really interesting. So I would complicate some of the socio-legal story that you're telling by also including these other sources.
Yeah. I'd say I've also learned so much reading your previous work, so it's pretty cool to discuss it with you. How squishy are the cliffs? Yeah, so I think the question should be, how good are EU lawyers, sort of? I think you're right, and that is the story that's going around, that there's going to be a self-certification system happening, and if that's the case, well, they're going to be quite squishy, I guess. I do think, and to give the EU bureaucratic system some credit, that these are people that are very judicious in this type of thing, and they reacted to the OECD definition, and they might be reacting to the scandal on Twitter and Mastodon, because that part of Twitter seems to still be, or X, whatever, still be a little bit alive. So
life support.
Yeah, but hanging on. But so I think it is a bureaucratic apparatus that seems to be responsive to that, and so that might be something that they somehow fix. But it is a problem of definitions. And again, one of the other things in that paper that I will count in 3, I hope, is that a lot of this actually is shifting much of the conversation to standard setting, and that is a huge challenge that I still don't know how we're going to deal with, because it is at the standard setting stage where what's something reasonable is going to be defined, what is a good interface is going to be defined, and then who's going to have to comply with what. So even though I think they've been very judicious, including what a good human in the loop definition should be, or a better one, and they've extended the definitions of high-risk systems, it's not only about the definitions in the legal text, but the standards, and that's a challenge of its own. So yeah, lots to talk about in this space.
Oh, wait, you were in line before. Yeah, so you go first.
You can go follow the. Yeah, whatever. Sorry, thank you. Well, with respect to the first piece of the AI Act piece, I have to admit I didn't manage to read it so far. But
that should stop nobody from commenting.
The idea that I wanted to bring up to the conversation was, well, my greatest criticism to the AI Act approach is that
And this is reflected in the definition of artificial intelligence that, as I said to some people individually over the last few days, I believe could be summed up by saying everything technologically advanced the European Commission does not understand, is that it's trying to provide a horizontal approach to regulation, whereas these things that we're trying to regulate are as diverse as high-frequency trading algorithms, the focus system of my camera, a toothbrush, and a driver's car, a robotic limb. So all things that are so diverse and fall into different technological categories, have very different technologies behind them, and at the same time would be treated in a social science perspective entirely different, because we do not regulate consumer products the same way we regulate financial markets. And so there is no technological unifying trade, and there is no social science policy unifying trade, because these things give rise to immensely different problems. So I think the most fundamental criticism that you draw to the AI Act through the definition is also that it's trying to regulate everything at once. And that is why that is the case. I think it's because it's a political statement of the European Union trying to say, hey, we're here and we are going to prove our position on in the AI global debate by saying that we're the first ones to regulate it. We are the regulatory powerhouse globally. We tried it with the GDPR, we're kind of successful. Let's try it a second time to play the same game. As for the liability piece, I skimmed right through that. It seemed super long. From a European standpoint, I would cut the number of pages by half, at least. And I know American standards is slightly different, but in the European perspective, I've cut the number of pages by half. And at the same time, there is a lot of relevant literature that I would advise you to take into account, because these directives have been already eliciting some criticism of publication. So, with respect to that, I think you have a very optimistic look at it, at the framework. I think that, again, the problem is to say we are trying to regulate the liability of things that are so diverse and provide very different incentives. And when the technologies that we're trying to regulate are so different, I think that the law will self-select the applications it can apply to, successfully apply to, because the incentives are not sufficient. So if I have a very small claim, we don't have, for the, I would say the vast majority, I'm not sure about all the countries, European countries, that we do not have ultra compensatory damages. So the claims would be, in many cases, very limited in the amount. And the whole procedure of the AI liability directive that requires you to sue in court in order to obtain evidence, and then you have to use to demonstrate a theoretically fault-based liability of your defendant, is absolutely unreasonable and feasible in most cases. People will not apply the directive. My bet is that we'll have 10 cases in the next 10 years, if we are lucky, or unlucky, I would say, actually. But at the same time, I have another criticism, is that apparently it's just a liability, it's not a liability rule, it's just operating on the level of evidence. Yeah. But that is actually not the case, because there is a reversal of the burden of proof, which is a paradox, because it first says, if you demonstrate fault, then causation is presumed, which logically is impossible, because you can only discuss fault once you have established causation, theoretically speaking. But this is a very German approach. It's a very German approach whereby causation is, fault is a failure to comply with a given standard of conduct that is potentially even unrelated to the harmful event itself. And the reason why it's a German rule is because it's heavily influenced by German scholars. I know you cited Christiane Vanderhust. There are others that were relevant in that debate, and also the officials within the European Commission that are working on that file are Germans, actually. So, but it's not even good German law, because not even Christiane would really agree with that solution. And actually, it's and then you presume the existence of the causal nexus. So if you read it as it actually plays out, it's more like an absolute liability rule in those cases where it would actually function. So I think that the European Commission is telling two stories. One, that is how it appears, and one is actually how it really is. And how it appears is a really bad story. But how it really is it's really hard to anticipate how it will play out. So I'll be much more critical, and actually I'm writing on this topic as well. I am much more critical about these proposals than, and I think that the paradox that there was so much effort into coming up with these pieces of legislation, because it started participating in this debate at European level. It was 2014. I wrote a number of studies, even on civil liability and AI. It was 2020. There was a debate at the European Parliament for many years now. So many scholars that contributed, even the work of the expert group on liability that you signed, would be very critical to the proposal as they were now framed, because they departed radically from everything that what European scholars have been saying over the past 5 or 6 years at least. So there's a big fundamental question, why so much discussion, why so much policy advice to then come up with such a solution, which really departs from everything what any scholar, any expert that was advising the European Commission said over the years. So.
Thank you so much. Do you want to take a stab at responding to that?
Sure. I'll start with the beginning and then would love to hear more about what you're writing. Given the audience also, maybe I'll focus on the systemic part of it. I think, I don't know, maybe I am a little bit more, I admire some of the work the EU Commission is doing. It's crazy ambitious. And I don't think it's actually totally true that they're regulating all at once. It is what they're stating, but if you look at your example of, I don't know, the smart toothbrush, that actually doesn't really, that ends up not being covered by any of these directives. It would be a low-risk application, and therefore most of the requirements under EU Act don't cover it, and therefore many of the things provided in the diabetes directives, if we go that far. Oh, I guess it would be a product, but then electric toothbrushes are already covered by the product liability directive. Like if that thing blows a tooth out of you, the situation is sort of the same. Yeah, but what I mean is that I think the EU AI Act is an umbrella rule that is horizontal, but then if you look at the categories, the high-risk systems are determined. There's a bunch of things that are excluded, so AVs, for example, are out of it because you're going to have sectorial regulations. So I do, in a way, sort of applaud the idea that there's this one thing that you can do very much in general without precluding that there will be very sectoral particular rules for specific type of AI systems. And I think that's kind of the balance between what should be ex ante and what should be exposed. I think you're right that the law will self-select and there will be most likely very few cases regarding AI harms. That's true for liability law anyways. Like I think there's a lot of people who are harmed in their life, and then the potential thing they might get back is just a low cost and it's more expensive to go to court, and so we don't go to court because as much as I like the law, I wouldn't advise that to most people. So I think that's just how the system operates already, and that's maybe okay because a hyper-litigious society is also not what we want, and it's why it's important to have an administrative state, and how we think about the administrative state is part of what we've been thinking today. So I think it's a systemic approach, and one of the interesting things to watch in Europe right now is how is that systemic approach going to develop. There's going to be a system of complaints, fines, administrative agencies, compliance agencies, but yeah, I don't think those are fundamental accusations that wouldn't apply to a liability regime that exists today for a bunch of other stuff.
I want to try to bring a question out of what you said for the other two authors also, which is, can you write a harmonized horizontal law for general purpose AI systems or foundation models without having these context of applications imagined?
Yeah.
I mean, it's a complex question. No, in the sense that I think the potential harms from general purpose AI systems does not necessarily depend on the context of use. There are contexts of use that may seem harmless, but in fact you can have harm. So in that sense, I would say the European Parliament approach of having safety requirements for all foundation models, for instance, is good, but no in the sense that how you operationalize certain safety requirements depend on context, which I'm sure you have thoughts about.
I think fundamentally you need to have both. A lot of the work goes in at the level of the general purpose AI system, not in how it is fine-tuned or deployed. And so there has to be some legal structure in place for understanding and regulating at that early stage. Also because it's not transparent to many of the people who are using these systems down the road, right? It's not transparent not just because of knowledge gaps. The people using GPT often don't understand how GPT works, but also because OpenAI is not transparent about that. It's not transparent whether you're paying or whether you're not paying. If you're an AI researcher, you still have no idea how ChatGPT is actually being built. So there has to be regulation at that stage. There also has to be regulation at the application stage, because many of the applications are doubtless misapplications, and this connects in with how the general purpose AI system is built. There are various things for which it was not only not designed, but is wholly inapplicable. It was not designed to do this is maybe the wrong question, as we're saying, but it is not suitable for that is still very much a question, a question that one can ask.
So I would love to see, I'm really very respectful of you guys and very appreciative that you're standing here waiting, so turning to you in a second. But I would love to see as a follow-on piece to this, the piece where instead of trying to tweak the AI Act at its edges to make it suitable, I would love to see the piece as a follow-on to this, instead of tweaking the AI Act at its edges to try to make it less of an ill fit for general purpose AI, a piece where you imagine what might transparency, safety, et cetera, requirements look like for regulation that's not context-based and is targeted at general purpose AI. Okay, thank you so much for your patience.
Has anyone been taking notes of this time here? That guy was like really good. A lot of stuff. I don't know how many notes and what he said. But in terms of like the AI regulations and like the EU package, do you think that Europe has done an effective job, has really done like a proper gap analysis to justify why we need additional regulation? Because we already have like consumer protection laws, copyright infringement laws, Equality Act and anti-discrimination legislation. Would we be better off just trying to implement existing laws instead of waiting for this AI regulation to be in place, given that it takes so long to introduce something new?
Yeah, I think the EU theory is that all of those rules apply, but that the qualities of AI systems make them very hard to apply. So fundamental rights law says the same, anti-discrimination law says the same, copyright, whatever, but systems are complex and opaque and sometimes autonomous, and that creates accountability challenges, and that's the conversation also here. So you have the rest of most of these tools are either, or like regulatory tools are oriented either at opening up the system one way or another, or testing it enough so that even if we don't quite know how they work, we expect them to work sort of okay for a long time. That's the whole idea of the apparatus behind. And so these are, so that's what the rules are oriented at. I don't think they're changing copyright, they're not changing, they're just creating tools to ensure that these rules that we already have are going to be able to be enforced effectively on the systems.
But do you think as well like there's a sense of proportionality with how it will be applied? Like for example, let's say you work in a private company, you're doing predictive maintenance with AI, and you're doing like a proof of concept on one refinery, versus you're doing one that's much larger scale. In terms of like the conformity with the impact assessment stuff you have to do, from what you've seen, does it look like there's going to be, again, like a sense of proportionality on the scale of potential harm?
Well, that's the idea of the high-risk systems. So if you are doing something that's high risk, then, I mean, at least that's what they're thinking. If you're doing something harmless in-house, you're just not going to really be bound to anything.
Because you could be under, like, let's say, safety-critical infrastructure, right? You could be within high risk, but one project could involve like a smaller scale, one could be significantly larger, but technically they're included in that same bucket. So how do we treat those, or should we have like subcategories?
Yeah, there's not an SME exception.
Yeah.
So but that's also an interesting regulatory design question, because it's a question of, do you tailor the cliffs, the squishy cliffs, by the impact and harm? Do you do it by the capacity for, regulatory effort? This one does not do it by regulatory effort.
Because something I'm just thinking, right, in terms of just being extremely practical, is often you just think that what are like the absolute worst things that we cannot have happen, and starting from there, like the prohibited practices, at least incrementally sort of introduce this sort of stuff, so you have like a baseline of like, and hopefully we can get to some sort of global standard, even though culture and ethics is obviously something to consider, where you just have that bare minimum, but at least we know that these uses are off the table, or these things are just, you can't do them.
It does try to do it with the unacceptably risky systems. So there is a baseline. Whether you agree with that baseline or think it's comprehensive enough is a different question. I'm mindful of time.
Yeah.
And I think what we're going to do, because you've been standing in line for a long time, is to have you ask your question and have a real back and forth. And then the three of you who are in line after that, we're going to lightning round, okay? Which means ask your question briefly, and they get to choose how much, the extent to which they're going to be responding. Okay, so full question.
Yeah. Thank you, Naomi from the Norwegian Research Center for Computers and Law. And it's more common to Beatriz. And thank you for writing this piece, because I do now work on a need-to-know basis. And I try not to read all the regulations from the EU, because it's just too much. And the AI liability directive is on my excluded list. So.
The liability directive is shorter than my piece. I'm sorry to say.
I know it's short, but still it takes too much thinking. I don't have time for that. I think maybe also, yes, so since it is a directive and it's a very early stage, I think actually to inform the reader, you could say something about the status and processes of legislation in the EU. So here for this directive, we do not have any of the text from the Council or Parliament, because they are not finished with their negotiations. And also, you could also see if it's important that this is a directive, not a regulation, which means that there is some room here for national implementation.
Yes.
But what we fall back on here, whether it's liability in here or otherwise, is that tort law is up to the member states, and it's very different, and we see examples of that. And since you mentioned GDPR, there are so many rabbit holes that you can go into here, but since you do mention GDPR, Article 82, so the compensation provision in the GDPR, so the experience with that one, also from the former Data Protection Directive, is that case law in Europe goes all over the place when it comes to compensation for data protection infringements. And we see that also with the GDPR. And you could maybe look at that since you already mentioned 82, so that's why, otherwise I would stay away. And the point of 82 is that non-material damages are not now, because that was one of the differences also between the member states. There are huge differences. So we have a case in Norway now, quite serious infringements, but the court denied any damages, and actually that court will be appealed to Strasbourg. We are members of the EU. So as a fundamental rights, and also with the AIA, you refer to the Parliament version as a current or the latest. It is one of three, so they are equally authoritative, and it should probably be mentioned. The trial, the optimists say that it must be done by New Year's. So it might not be important for your piece, because of course the high-risk categories are quite similar. Some differences, insurance is mentioned in the Parliament version, not in the others. But I was going to say, yes. But upon since human intelligence was mentioned as well, you may also consider again, since you already used the GDPR, we'll mention Article 22. There are similarities between Article 22, so and the high-risk categories. But lastly, on page, Under point 6, you write about AI fundamental rights in the case of data protection, and you mentioned that the liability directive will not be applied if there is human assessment. You can use examples that you have. So you mentioned the Dutch child benefit scandal. That is an example of a case where the algorithm was only very small part of the case. There were lots of humans in the loops. Right. So, and would that use of AI fallen within under the liability directive? Mm-hmm. I'm not sure. And there are other cases as well, and you might have a look at Schufa. Since in the Schufa case, the EU Court of Justice then said that, well, it's a part, the final decision happens later, but the decision made by the algorithm is so substantial and influences the final decision, so that it must be considered to be the final decision. Yeah.
Awesome.
So
Thank you so much. I will have this.
One last moderator's privilege before lightning round. I neglected to mention in my comments the whole thing about material harms and fundamental rights. Yeah. You have such a potential for a dialogue there with the US literature on privacy harms, because I think there's this, I know I'm also guilty of making the assumption that like privacy harms are treated so much better in the European context, but to go outside of the GDPR framework and point out the fundamental rights harms vary so widely across member states and therefore limit the application of the AI liability directive in this space. That's like, that was one thing that you said on like page 66 and I wanted it to be an entire article. Okay, lightning round, let's begin. We'll go Woody, Jesse, right? And then Andrea. So
time.
No, just ask your questions quickly. And then the time will be as to how much time you guys have to respond. Okay.
And we can go, we started a few minutes late, so we can go a few minutes over to.
Okay.
So I say that
yes,
because
boss.
I'll do my best to keep this concise. So, Margot, you asked, well, first of all, what do you guys are evil? Margot, you set me up perfectly thinking about privacy harms. One of I've been thinking about two things a lot lately. One, obviously, which is scale. The other one is the concept of normalization. And I wonder what role that plays. Reading both your papers made me think about how normalization might play into this in two different ways. So in work with Evan Selinger and Joanna Gunawin, we talk about how the law, basically by its structure, by focusing on harms, set at particular thresholds, which is a lot of what we're talking about here, or by managing risk and excusing a lot of stuff that sort of isn't too risky, it actually ends up normalizing all kinds of expectations, which then allows things that were once considered to be harms to no longer be considered harms. Now we might think that's good, maybe that's progress, but the problem is if you've got no backstop, there's no end to that line. And we end up with these dynamics, one of which is unacceptable habituation. We become used to things due to their very exposure, which then leads to favorably disposed normalization, where we come, because we see everything around us all the time, we think this must be normal, therefore not bad. And I wonder how that plays into either of your analysis in two different ways. With the human in the loop, it makes me wonder, is it possible that the role of normalization that is being unaccounted for, as I see it, in any of the legislation, makes humans in the loop an unreliable narrator, or one that is subject to a kind of creep and slow sort of ignorance of all sorts of things that we once considered to be harmful in a way that we might want to resist against a human in the loop for that very reason, right? Or is there some sort of fallback that we can push back? And I know that Margot and Nicholson probably have a lot of thoughts on this as well. And then the other one is the general purpose AI makes me wonder how that accounts for the spillover effects when if we say general purpose AI sort of is fine and sort of operates in the background and doesn't lead to these specific harms in this particular context, but it doesn't address the spillover normalization effects that sort of opening up the door and allowing these systems to come in has. And so I didn't know if that plays into your analysis at all, or if you think it's irrelevant, but I'd love to hear your thoughts on it. Maybe not now, because lightning round, and apologies, but maybe afterwards. Thank you very much.
All right, so hold your thoughts on those. Jesse.
Hi, Jesse Wu, Columbia University. So I have hopefully a simple, like yes or no or quick word question. But Beatriz, I was really pleased to see your discussion of like the complexity of these systems being not just within the models themselves, but the whole kind of development, train tests, like pipeline. And you at various points talk about like deployers or producers. You know, you have different terms. I'm wondering, are these legally operative terms? And you know, because I'm reminded of the GDPR, which had very specific definitions and responsibilities for different players in the ecosystem. So how are these different deployers or producers being treated, particularly in this ML ops kind of thing?
So good.
Yeah, so I wanted to make a very short comment question about effectiveness. I mean, I think the whole purpose of adopting dedicated legislation in the field of civil liability and artificial intelligence was current rules are hard to apply.
Yeah.
So if you make the claim that there will be very few cases when these norms will be applied and this is not a problem, this is actually the problem that the European Commission is trying to address. And we already observed this with the Pro-Liability Directive. Because there are studies, empirical studies from 2018 that show that the Pro-Liability Directive in Europe in 25 member states across a 16-year period of time was only applied 540-something times, which is nothing. It's a very low number. And the cases where claimants were successful are like less than 40%. And in like 30% of those cases, other norms but the Pro-Liability Directive were applied. So meaning that contract law and general tort law rules were deemed preferable by judges in order to ensure protection to the claimant. Long story short, this piece of legislation is totally ineffective, and this is the reason why we have decided to attempt to reform it. This is just a matter of fact. So the thing is, I have a great concern if we are trying to adopt new legislation and we already know that those legislation will be almost impossible to apply. Because we do not have the same problems that you have in the US with excessive amount of litigation and stuff. We do not allow for ultra-compensatory damages. And the very reason why the European Commission was trying to adopt these pieces of legislation was primarily to ensure some form of compensation to victims that will otherwise go uncompensated. So don't you think that this is a serious concern and a serious criticism to some pieces of legislation that still need to be enacted, and that present all the weaknesses that the previous legislation already had and do not provide any radical improvement of those that were identified as necessary?
All right, and we have one more lightning strike.
Right, and just really quickly, I just realized we have till 2:15 because this is a two-paper panel, so we can actually build it out just a little more.
Yeah, no, I was aiming towards 2:15.
Okay, I'm sorry.
Yeah.
So I'll bring thunder instead of lightning. Just a small point to Beatriz, I want to echo Jesse's comment. I'd love in the complexity section to just see more on algorithmic supply chains and the sort of specific actors in that space. I'd point you to a great piece by Jennifer Cobb and Michael Veal out of CAP this past year on accountability in algorithmic supply chains. I think it would just make it stronger, but overall, both papers. Thanks so much.
All right. So we have normalizing. Was the amazing question from Jesse?
Deployer.
Right, deployer, the definition of terms. We've got, this isn't going to work, and we've got supply chains. Take what you want. And any final things you want to say?
I mean, I was just going to briefly respond to the vocabulary one. The AI Act introduced some vocabulary that was very confusing to people. Producers are called providers, and then the users are the ones who deployed an AI system in certain contexts, which has created a lot of confusion in the public because systems can be used on other people, but they're not the users. And then this, And so this language was different from, for instance, the PLD, the Product Liability Directive, and so in the two revised versions, well, the two directives on AI liability, now they're revising the language to align it with the EU AI Act language. So basically a provider is a producer, a user is basically a deployer, and there's an importer, and then basically all these terms are under the umbrella of AI operators. So if you want to talk about any AI actor under the AI Act, you can just write AI operator in your paper, and that will always work.
I will take that. That's good advice, thank you. Yeah, I'll just add that I do think that it may be the case that those definitions will collapse very quickly, the way we see controller, data controller, and data processor collapsing in more complex, like in cloud services, that doesn't make any sense. And I think one of the things that later drafts have done in the Act is that they have tried to equalize the obligations of producers, who are the people who say place the AI system in the market, and deployers, the one that say get the license or buy it and use it in whatever their business is. And they have increasingly equivalent obligations, so that might no longer be, I mean, lawyers will fight about it, but I don't know how consequential that is. I'll say that about that one. But yeah, I've read some of Jennifer's work on this, and you're right, it's super relevant. Thank you for that. I'll take the normalization question. It's a hard question. I'll have to think more about it, Woody. Thank you. But I think in an ideal world, what the complementarity of having the ex ante and ex post regulation is that you're sort of trying to avoid that. So I don't think it is necessarily true that risk regulation makes certain harms legal, and there's a difference to be made somewhere very theoretically about illegal and legal harms. And we have a bunch of legal harms out there. My parents are outraged because someone's building a house in front of theirs, and the sun will be, well, that's the classical example, right? But I think that if you were able to design a system that is successful in balancing both, you have a system that ex ante tries to mitigate some risks, but still understands that harms might happen, and you have a system that ex post creates tools for victims to get redress when those harms happen. That might not be necessarily the case because litigating is hard, because it's expensive, especially if the incentives are not right in place, but I don't think. And then the problem with the human in the loop, yeah, there's of course a pushback against having humans as this type of buffer between regulation. And I think maybe not very successfully yet in my piece, that's also sort of what I'm aiming at, but I'm also trying to look at some of the more technical scholarship that I've learned a lot from, that those interfaces can be more complex, and there's instances in which in machinery or aircraft, aircraft flying, that interface has been designed to have successful examples, and it doesn't really have to be the case that the human is there to somewhat receive control of a car before it crashes.
I have one addition to that, just because it's funny. Everybody needs some humor at 2:10 after lunch. I'm recalling Paul Ohm's suggestion about the human in the loop piece last year, which is to have a category. We had like 8, 10, 6, I don't know, how many ultimate categories of like what functions a human in the loop can perform? 9. Andrew criticized us for that. But Paul's point was like there's a performative category, which I actually think under your term is a normalizing category, which you refer to as the royal family performance. We don't know exactly why they're there, but we kind of like having them around. Speak for yourself. Yes. Not adopting that normative point of view.
Not adopting.
I guess since we have a few minutes, I want to clarify, is your concern with spillover effect from GPAs the fact that if we regulate them, we make the public feel like they're safe and therefore it becomes normal to deploy them in all sorts of contexts?
Yes, the idea being that allowing, and that if you get used to the way in which general purpose AI functions, then that probably carries over into other areas where we might actually have specific regulations and context-specific AI, but because of a collective shaping of expectations around what is appropriate, good, or bad in a scenario, it might actually end up sort of shifting the threshold at which we would draw the line, and maybe that's good or bad.
Yeah, so it's funny, the debate on adding general purpose AI system into the AI Act was focusing so much on this argument that was not true, I believe, which was if we don't have general purpose AI system in the Act, there's a loophole because then the burden of compliance will fall onto the people who deploy those models. I think what would have probably happened would be that those general purpose AI systems would not be deployed in the context classified as high risk under the Act, just because it wouldn't have been possible for deployers to comply after the fact. But the thing is, my own belief is that there's so many harms that can occur outside of this under-inclusive list of high-risk system. And right now, I think it is being normalized to use general-purpose AI systems in all sorts of contexts in our life. And so that's why, for me, like having a risk-based regulation of those models is really important.
Yeah, that's I think that's one thought on that is that the broader literature on risk regulation talks about how risk regulation as like framing is about accepting risks so that you can use technology. So very much connecting to your idea of normalization, right? Like risk regulation is not a ban, typically. It's like, let's mitigate enough of the risks so that we're going to have some harms, but we accept those harms on a society-wide level, so we're going to use the technology.
Right. Can I have a small anecdote? So, I don't know if you just changed my mind very quickly. No, I think there is that effect, and it made me think. I read it before about cities and city regulation of tech. And one of the interesting things that you get this argument, especially in the US, that cities were created, like, or were designed for cars basically since the 1940s or something. But one of the interesting things, if you look at the law of that moment, is that cars used to be very much banned before. So it was, people would have to get a permit a week before they planned to take their car out, for example, which really made it hard. And then eventually all these rules just got repealed, and other stuff came, the new law came to create highways and so on, and suburbs. So there is that rule, right, in which you had this idea originally that cars were dangerous by default, and then the rule changed default. And maybe the challenge with that is that it's inherently kind of a political question of how we're valuing that these tools might have some very useful applications in the long run, and so we'll swallow the harms, some of them, or not. And I don't know how that looks like for generative purpose AI systems. I totally haven't seen what are those amazing applications, although it does help me write emails sometimes. But I think ultimately it's about that cost-benefit analysis of what we think these things can do and can't, and what we want.
Take us home.
But the thing is, cars became somewhat less dangerous. People for sure. From our driver's education stuff, but also we decided that X number of deaths a year was worth it.
Yeah.
Which is the really scary part.
Yeah, for sure.
I think that's a great way to end this session. Please join me in thanking
Get started. Thanks, everybody. Last, but most certainly not least, we have a really exciting panel for you, so I'll let Meg begin.
Thank you. Thank you, Woody. Thanks to everybody who is still here and came back from the coffee break on time. Yes. This is our last session of the conference. Yes. And I want to start us off with a little activity to help us kind of think big about ourselves. A little therapy session here, thanks, inspired by Maria's amazing piece. I'm Meg Jones, by the way, from Georgetown University. Maria Engel, I say Angel in my head, that's how I think about her, from University of Washington. Has written this really, really wonderful piece. And to emphasize that point, I would love everybody to take a scrap of paper out or like a clean screen. You know, just someplace you can type. I want to give you a minute, and I want to go through these questions, and I don't skip ahead. Okay, so clear your mind. Describe the future, a future you'd like to see that is achievable through the regulation of innovation, which, by the way, is what we've spent the last 2 days thinking about. Describe it. What is it? You got 1 minute.
Is this fine? I didn't even ask you about this. No, it's good.
So just one, not two.
Don't go to 2 yet. Thank you.
Is this a comprehensive vision of the future or just one aspect?
Just do your best. Just do your best. You got 1 minute. Just do your best. Okay, I looked at my watch like I was keeping time. I feel like that was about a minute. I sort of lost track. So number 2, describe what's wrong with someone else's vision of the future that's supported by some innovation policy idea. A minute again, and this time I'll really time you. Okay, stop. Now, the third question, what should the techno-legal imaginary, which we're going to talk about, what should the vision of the future be for the we robot community? I'm just going to let that question percolate for this session. And with Maria's permission, hopefully she doesn't mind, I'd like to invite the room to engage with her article after I finish introducing it, but also this question, and to think about how her article raises this issue for this community and the people in this room. So, what was the point of this exercise? Well, one, just to get you thinking in the headspace that I think Maria is asking us to think about, which is not in the little details of the law, but these really big questions over big timelines and kind of fairly large groups of people. Also, to enforce that this is super hard and no one articulates it. I found this activity, these questions, really, really hard to answer. Even the one that asks you to just criticize somebody else's idea of the future, I found quite hard. And often it takes someone climbing to the cliff to see what the forest really looks like when we're all down, in among the trees making our own research. So the way that Maria has managed to capture these imaginaries, these techno-legal imaginaries, which I'll talk a little bit, I'll go into more about what she means by that, is she has analyzed 30 years of privacy law scholars conference, so the PLSC community. Could you raise your hand if you're in the room and you identify as a PLSC community member? Okay, so that's what you're looking at, rest of the room. What Maria did was analyze papers from 2002 to 2022, which is about the length of time that the conference has run, to determine our community's vision of a desirable future achievable through the regulation of technology. And so this changing techno-legal imaginary for a very concise scholarly community. So the first thing I want to talk about is I want to talk a little bit about organization and then talk a lot about your findings. So how would one go about figuring out the imaginaries of a very particular scholarly community? Well, Maria grabs all of these papers, which is actually even more complicated than you realize because they're confidential. Like they get destroyed at the end of the conference, so it's actually pretty hard to track them all down. Through 2002, 2022, as well as some law review articles that were published between 1992 and 2002 that were cited in those PLSC papers. She then narrows the scope of the analysis of the thematic the themes of those papers just to information privacy, and then added some additional articles to the analysis, and then did some oral histories. So Maria can tell us more about those choices. I have some specific questions just to help me understand a little bit more. But according to Maria, we find that shared patterns of thought by looking at regulatory discussions about type policy, and PLSC is a great place to find kind of formalized discussions of tech policy. So she explains the performance of these expectations, again here found mainly in law review articles, and how they come to being through very real forms like we would see these in funding, research agendas, and public perception. So there's this section 3 that I want to spend some time on. This section 3 tells us that in the 1990s, law scholars were calling for an end to self-regulatory regimes and wanted to pass legislation that essentially enforced some version of the Fair Information Practices, FIPS. The scholars cited in that paragraph are not familiar to me, as like maybe because I'm not a very well-read PLSC community member, or like maybe because I'm like a version 2 PLSC scholar, but I wonder about their understanding of the field given that I don't engage with them in it now. Anita Allen is not one of these people, but one of the things that I found a little hard to maneuver through section 3 was that she's in there as an advocate for individual control, which is not how I understand her work. So I want to come back to this section because you express some uncertainty about it in the note to the reader anyways, and so I'm going to just sort of skip it for now and see if you can help me understand what that section is trying to do and go from there. So what I see the findings of this study to be are in section 4 and section 5. So in this first era of PLSC scholars that are focusing on PCs and new networks, we're working with 2 narratives. So the first really seeks to foster this free, liberal individual, and the second sort of narrative thread is about the social value of privacy. This era, I think, is really defined, according to Maria, by autonomy. Efforts to strengthen, establish, protect autonomy of individual actors, and through that protection, achieve some collective benefits. So Maria says that this vision, by following these narrative threads across these legal pieces of scholarship, we see a vision of a pluralistic, free, and democratized society where autonomous individuals thrive, which sounds pretty good. And then in section 5, there's this pivot that happens, and it's in the paper, it's aligned with algorithmic decision making and AI, and the narratives that we see there go beyond self-determination into human flourishing. And as I was reading this section, I was wondering how many PLSC scholars would be able to tell you the difference between those two very well. Like myself included, I would be tripped up and got a little bit tripped up. And I think you've wonderfully captured Neil and Woody's ideas in that section. But it's sort of through quotes, and that distinction, because it's supposed to separate and serve as this pivot, I think it would be helpful for me, at least, as a reader to understand it more distinctly. The second narrative is about power asymmetries, and Maria says that PLSC scholars have always acknowledged power asymmetries, but the way that I read this was that the early era was just sort of like describing these asymmetries. They're like, you know, complainers. They're like complaining. And then this new era of privacy scholarship really saw law as a way to affect those power imbalances and beyond rights. So not through like individuals acting out certain rights, but by actually engaging with the power asymmetries through different types of interventions. So this is related to the third narrative that portrays law as a legal tool to protect marginalized and vulnerable populations from oppression and subordination. So this collection of narratives results in a vision here, I think is active, live, and well. 2022 was just yesterday. And this is a vision that is one of a socially just society where companies are held accountable and individuals are protected and empowered to fully exercise their rights. So we have these kind of two moments that are captured and that, you know, we can discuss how they're framed and how those were motivated and whether the narratives capture what happened. But first I wanted to thank you for this wonderful paper. I really loved reading it. Not only do I think you did a bunch of really hard work for us here in this piece, but I also think that these types of exercises make us much more mindful as knowledge creators and legal participants. So like I said, question 3, we're doing this right now. We're doing what Maria's paper is outlining right now here at We Robot, and it's an opportunity for us to prioritize and reflect and set our own standards as a law and technology community. I'll be really interested to see what the STS, Science and Technology Studies, understand your contribution to be. So the techno-legal imaginaries that Maria, I think coined in this piece builds off of STS, socio-technical imaginaries, and techno-scientific imaginaries that think about how people try to bring in visions of the world through science and technology. And so this very nice complement of a techno-legal imaginary sits up against that. And in your intro to the reader, you said that this would be submitted to an STS journal. And so I'm really curious to see how they understand this as a contribution to STS. But to me, it's a clear contribution to this community and helps us understand as a community how we world build. So I've got 2 conversation starters, but I would like to invite people while I'm setting Maria up to talk for a little bit to come up to the mics and reflect on any and all of this. I'd first like to better understand your method. So some of the quotes that you pulled out in that the discussion of the field were sort of foreign to me, and I think in some ways you're doing this really hard exercise of mapping power and influence within PLSE, which seems awkward to me, like it seems hard and awkward to do. And I want to know how you're doing that. Are you looking at citation counts, citation networks? Are you looking at like symposium involvement? You know, when we try to figure out, when we look at historical records and you look at, you know, who are the people in the room really listening to, you know, like who really matters when they talk, like how are you trying to find that in this? And maybe you're finding that through the oral histories or some other method. But I'd love to better understand that. And then the second thing I'd love to hear more about is section 3. So once I got to section 4 and 5, I didn't understand why section 3 existed on its own. It sort of felt like it was part of those already. But I can also imagine it as a very effective last section where you explain how the imaginaries become real. Like, turn into like political, you know, advocacy I think that's sort of what I read section 3 to do, but I think maybe we're trying to do something else there, and I would love to better understand what that section was trying to do. So please tell us more while people line up.
Perfect. Thank you, Meg. Thank you so much for your comments. Thank you all for taking the time to read my paper and be here on a Saturday after lunch. I really appreciate it. So, to answer to your comments, let's start by section 3. Yes, as I told you in the introduction, I'm really confused, but the utility of putting that there. But having said that, I also gotta say that I have this other paper that I presented at PLC, which goes deep on the algorithmic turn, on this change of tools, and not only tools, but also harms that scholars used to recognize 30 years ago and now what they are doing with their scholarship, right? So I didn't want to bring all that content here because many of you have been at PLC probably this year, they were there, you read my paper and it would be boring, but also because that's not the main issue of this paper, as I think you recognize. The main point of this paper is to talk about the techno-legal imaginaries that are underpinning those different regulatory positions, right? So I actually think it's super helpful what you just said about turning the section 3 into the final section, because it would be a good way to show how, in this specific case, these imaginaries become performed or become a reality in the different papers and proposals, regulatory proposals that the scholars do. So that's a great idea. I'm still struggling with how much detail I should put into it, taking into account that the previous paper also touches on this change of regulatory approach. The difference between autonomy and human flourishing. Okay, yeah, that's a hard one. I totally recognize that since the beginning of the ages, privacy scholars have been talking about human flourishing without really knowing what they are, right? But what I want to say, and I think that I use in STS people, or in social sciences better, they use a lot of quotations and to bring the examples of the data that they collected, right? That's the way. And actually, I was recently doing an internship at Koprivcic, and I remember Tarleton Gillespie saying me, like, okay, that's imaginary, I'm talking about other imaginaries, but show me the evidence, like, bring me the quotes. So I know that here it sounds a little bit off to put so many quotes, but in the type of people I'm expecting to read, which are STS community scholars, I think that bringing this type of evidence is useful. So in that type of evidence, you can see that when they talk about human flourishing, they're talking about autonomy as one of the things they mention, but they mention way more things. Okay, so they actually mention well-being, and I think that that's overachieving, like super encompassing. It means we don't even know what well-being is as well, right? But it goes way farther than autonomy. So I think that was my point with that first narrative. Like, it goes to really a super powerful concept or value that now is not only in charge of making sure that the person is autonomous, but also that it can live a good life in general, okay? So that's the difference I see, but I can go deeper into the difference in the paper. Complainers of power asymmetries versus action on it. Yes, you're right. I think, actually, Dan Solo told me, like, I have been talking about power asymmetries since the beginning, and that's right, and many other scholars have done that, and that's why I put it there clearly. Like, this is not the big change. The big change, I think, is that earlier, in the early 90s, what they were saying, like, okay, we recognize that there are power asymmetries, and what we're gonna do to try to intervene it is give more rights to the people, right? They're gonna be in charge of taking control and therefore being able to get to the level of the other people who are controlling their data. But the point here is that, what I think is that currently legal scholars are actually asking the law to take action, not citizens to take action, but the law to take action into the power asymmetry. And that's why I say privacy law there. Different from the other narratives that I say privacy is considered whatever, I say privacy law is seen as a tool to make this change of this, or intervene this asymmetrical distribution of power. So I think that's the difference. What STS thinks about my contribution? I don't know yet. We'll see. But I can advance some things. So first, not to offend anyone, but of course, like,
legal scholars are not that appealing compared to policymakers, right? So when it comes to funding, for example, I have always received this pushback of, okay, so what? Like, I don't care what they care about. But I do believe in this community. I do believe on the power that these values can have on the ideas that are pushed forward, and that these ideas are actually impacting public policy. I do believe that. And I also believe, taking into account what I have seen working not on scholars but on policymakers, that it's actually way easier to trace the values that are underpinning the ideas of scholars than the ideas of policymakers. Why? For many reasons. Partly because they react to what people are telling them to do, but also they have less time to plan what they're going to propose, right? And many times they don't actually do it. They consult on people like you to do it. So I do think that if we want to trace the values that are underpinning these type of interventions, we should go to the source. And in many cases, not every case, but in many cases, the sources are actually in academics. They might also be in civil society, for example, and that's another section of legal actors that I will be investigating in the future. Hopefully not so far. But so I think that on the one hand, it's not that appealing in the sense that this community is, the ideas of this community are not as performative as the idea of those policymakers, for example, in the view of STS scholars, although I think something different. But also, I think that the bigger idea that I propose here, that is more theoretical, as you say, is the first time I publicly, okay, I mentioned techno-legal imaginaries in my previous piece about the algorithmic term, but I developed the term here. It's the first time I do it. And the fact that I talk about legal actors, to talk about it, not only scholars, allows me to offer this as a way to analyze what's going on in whatever legal actors do, not only scholarship, but also policymaking, etc. So I do feel that they can find this helpful to analyze what's going on in legal spheres in general. Having said that, I was at Sheila Jasanoff summer school, STS summer school, and she was like, why don't you use my term? Like, why don't you have to use
Sheila Jasanoff is, you know, a STS OG and a lawyer and has lots and lots of law in her.
Yes, exactly.
Bio, socio-technical imagination.
Totally.
Yeah. So what did you say?
So at that time I was super intimidated and I was like, okay, maybe, I don't know. But now I have an answer. So as you see, I take her concept, socio-technical imaginaries, but I also build on other concepts, right? So I bring George Marcos' concept of techno-scientific imaginaries, and I also bring the sociology of expectations. And the reasons why I bring both are, first, Marcus gives me the possibility to focus in smaller communities, right? If you think about socio-technical imaginaries, for those of you who are not very aware of them, normally they are talking about big policy changes, the imaginary that a whole society have or has, or that policymakers have. I wanted to have the freedom to actually talk about imaginaries of smaller groups that may not be so influential, but that still have performative effects when they use these ideas. That's one thing. And I used the sociology of expectations because it gave me more freedom to talk about the performativity in a less ambitious way, right? So for example, they said, like, we focus on scientists and whatever they write and the funding, for example, the effects that this can have on funding. I think in this community something similar. You can, of course, have some effects, but not super performative effects, as many other people would expect from the imaginaries from Jasanoff. So I try to build on many other concepts and not just restrict to that one, because I feel like that would be a flaw in my argument if I stick to that, to use it in these smaller communities.
Yeah, I feel like I'm going to do something I never thought was possible here, because we're always asking, well, what is special about the technology? Like, is the technology even relevant to this, or is just this in everything? And I'm going to ask you this question: what is special about the law here? That's the question, right? Yeah. She's asking you, like, this already accounts for all of these forces. And we have this question in the legal construction of technology, which you gave an acronym to, and it made me so happy. It's got its own acronym now. But it is, it is hard, and we think it's important, but I'd love to know why you think that it has its own
That's important.
focus.
Two, if you remember the socio-technical imaginaries that Jasanoff and Kim propose are about the visions of desirable future that you can reach with technology, right? Here, I'm not talking about that. Are the visions of desirable futures that you can reach with rulemaking. And I think that's noble compared to what she does. So I think that's why this is different. What she gives us is visions of the future with technology. What I'm trying to give here is visions of the future with legal interventions. That, as I said, I understand it in a broadly way, like Lessig, the regular way. It's not only the law, but also through other means, social norms or technology or the market.
Great.
Method, right? I have to keep adding more details. I know I received some comments about method at PLC, and I think that I still have to be more conscious about the details of what I did. First, you said that some of the quotations I used at first, in part 3, I think, are not familiar to you. Partly it's because those first days, the 90s, early 90s, were not PLC. So that's why maybe it's not that familiar, and I had to go back to like Porsche words and the Porsche words is
PLC.
But I think that, for example, the fact that in talent that you don't recognize her with those views, that's fair, but that's the evolution of her thinking over the years. I think that I have encountered that in many others, and as I said in a previous version of the PLC paper, I think that that's not a contradiction. It's just how we all evolved as human beings, right? We think one thing, and given the change of circumstances or whatever, we can change our minds or evolve in our way of thinking. So I do believe that initially she was she was sticking to the idea of autonomy and tips, and nowadays she's much more about social justice, and we don't really have to care what privacy is as far as privacy is being useful to move social causes. So, and I actually interviewed her, that's one of the people I interviewed, and she was fine with, she thought that's normal, that her ideas have evolved over time. About social mapping and how did okay, so my oral interviews are actually, the essence of the oral interviews are that they should be published, right? So eventually they will be out there for every one of you to take a look, but it's very astonishing to see how the network of people I asked. So I asked my interview, who have you worked with, who have been your mentors, who do you usually reach out? And it's very fascinating to see how the map is really repetitive, you know what I mean? So that's one thing, and I think that's being reflected here partly. But also, I gotta say that what I do is that I find trends. That's what I have been doing in the papers. I have been finding trends. So I don't really care about whether this person is more cited or less cited, but if I'm seeing a trend, I identify the people who are being part of it, right? So that's the way I have been taking these quotations from people who are joining the trend. If you read the other paper, the Privacy Algorithmic Torn paper, the PLC paper, you will see that I have another section about the critiques. Because of course, this is not the whole community of PLC, and of course not the whole community of privacy in the US, right? So there's another chunk of people who have resisted this change. But here, and maybe I should be much more clear about that, I'm just concentrating on the algorithmic turners, the people who have actually embraced this turn, and to understand what are the values behind their choices. Yeah.
Great. Go for it, Woody.
I get to be the first. Excellent. Thank you very much, Marina. Just like your last paper, PLSC, I really, really enjoyed reading this. Thank you for this great contribution. I'll go ahead and say that there may be some people in this room who are thinking, how is this We Robots? How is this a We Robot type paper? This seems like a privacy law paper. And apart from the sort of substantive overlap of privacy law with We Robot, traditionally, I actually want to make an argument that I think this is very much a We Robot paper, and recognizing that actually might help you frame even the PLSC part of this paper, and I just want to provide just a little context about why that may be. One of the things I was really interested in, I was reading your paper, is thinking about what was happening alongside in the world as these sort of techno-legal imaginaries changed. And one explanation for that might be that technologies change and the world changes and it affects us in certain ways. And so we start off with this promise of, social media is pretty great, and then you try like, oh right, no, it's pretty horrible actually. And we have this approach to regulating things. We're like, we're going to try this control, and then we try it, and then you're like, oh right, that's a disaster. That's an abysmal failure. So changes in FTC regulation, it could end up sort of shifting around legal imaginaries. But I'd actually like to make the argument that at least for my own parts in some of this, We Robot actually played a large role in it. And that's the role of interdisciplinary collaboration in this story as a way of changing what we see as legal scholars as possible. And I'm specifically thinking about even the very first We Robot, where Bill says, robots are hammers. I showed up to We Robots like, robots are magic. And he's like, well, not. Sensors are, slow, wrong, and Bill gave a pre-workshop talk where he's like, they don't measure what you think they measure them poorly, and then there's like one other thing.
Noisy and wrong.
Yeah, noisy, lazy, and wrong, right? Noisy, late, and wrong, right? And so I was like, well, that changes the way that I see a lot of this. And one of the, Michael referenced our collaboration we did with computer scientists trying to integrate laws into algorithms, which is like a very popular thing. But if you team up with other people from other disciplines, you're like, well, that sucked, and it's going to not work at all. And it profoundly changed what I thought law's role could and should be as part of this. And so I just think that if that's not this paper, you've got a remarkable research agenda, and I think that you're building on some really important concepts, and in a very narcissistic way. Of course, we're like, oh, very important and worthy of study, right? So you should continue to do that. But I do think there's something there, and I think there's room for this to be expanded, and I think that not only sort of what's happening in the world, but the idea of interdisciplinary collaboration rather than legal scholarship as kind of a solitary methodological endeavor can give a lot of color to a lot of what you're working on. So I just put that.
That's a great comment. Yeah, I did make a note to you that said you'll have to tell STS scholars what PLSC is because they'll definitely have no idea.
Yes, I know. And I wanna. Okay, can I?
Yeah, sure. Yeah, I think we're there.
Because I'm aware that question will come up. Actually, to be honest, Michael Franklin said it to me previously, like, it's a fantastic, very lovely paper, but it's not very robot. And I'm very I agree with that. It's not a robotic paper for We Robot. But I gotta say something additional to what you said, which I agree with. I think that partly that's intentional because, as you saw in my theoretical framework, we have always been thinking about law and technology and the relationship, right? And in this paper, I may mention AI 3 times, maybe. Why? Because I want to give protagonism to these other dimensions that Meg has been trying to bring forward with the legal construction of technology, such as the social, but in particular the cognitive dimensions that may be influencing law. I don't know if more, but in a parallel way to technology when it comes to the change in legal reasoning. So it was in purpose because this is a space where people talk a lot about technology, but let's stop for a while and think about other dimensions that may be also influencing the change in the legal reasoning, such as imaginers.
Hi, Nicholson, Vice Commissioner of Law. I don't know STS or privacy law very well, so this is a deeply ignorant question. It may also be naive. How much does it matter, how much does the constitutive dissatisfaction of law and legal academics matter to the picture of the imaginary? Because, I mean, it might be that it's just baked in, that you don't imagine the way things are, you imagine the way things want to be. But I wonder about the fact that as academics and legal academics, we are really constitutively unable to say, you know what, this is pretty good. Because it turns out that's really boring and uninteresting and you'll never get published and nobody wants to hear what you're saying. What?
Job well, journal things we like.
Right, sorry, except job well. The scholarship is good. I mean, like, a state of the world is a good thing. Congratulations, we achieved an objective and it's working well. It's just not an interesting type of scholarship that people tend to engage in very much, or at least it's hard to make it interesting. And I wonder how much work that's doing and how much how much is there unseen that might matter in the context that, from an academic perspective, things that work well tends to be understood, especially in legal academia, right? History is like, cool, if we did a thing, it works. Neat, that's a fact about the world, but legal academia doesn't tend to do that very much, and I wonder if that matters. Maybe it doesn't.
That's a hard question to answer, but thank you for it. And what comes to my mind first is Daniel Susser's recent essay, I would say, about the socio-technical imaginaries of surveillance as privacy scholars. And what he says there is exactly what you're saying. Stop thinking about all the bad things about technology and tell us what, therefore, can we achieve with technology? What good would be achievable? So I agree with that, but I think this is a different argument in the sense that I'm not criticizing. Okay, maybe I'm being critical, but I tried not to as much as in the other paper, which I was much more critical. Here, I'm just trying to describe what I'm seeing. That might be one of the reasons why this is happening. But, for example, at PLC, I heard another possible reason, which is the people at PLC are constrained by funding, now everyone wants us to write about AI, that's what it's appealing, so maybe that's why the literature is changing. I agree with that. I'm just pointing to some of the possible elements that may be driving the scholarship. One of those being this one, and probably one of those being the one that you just mentioned.
Thanks.
Hi, I have a quick comments because Woody said a lot of what I wanted to say. So firstly, I just wanted to, I guess, +1 to adding some more about not just why PLSC is important, but if we're doing like a historical analysis of PLSC scholars, I'm curious if you could gather information on why PLSC started in the first place. Like just for like a non-PLSC reader to understand, to convince them why this was important. Because you start in the 1990s and when PLSC was arising, but like what was it that caused this community to form? So maybe that would be a good thing to add at the beginning. And then the second brief comment, you talk about this transition from A to B, and maybe adding, you like very descriptively and very nicely like describe what was going on in A and what was going on now in B. But I'm curious if there's room in the paper for why, and this Woody was kind of getting at, like why was this happening? And I think it partially not only has to do with the changing of the world, but also the changing of the makeup of the PLSC community. So I would imagine, and I don't know this for sure, but I think that in the 1990s, PLSC was like all law scholars, and now it's not. Like now there's computer scientists, social scientists, and maybe like what he was saying, like this is influencing the way that the law scholarship is forming. So maybe just having a little bit more of that would be useful.
Thank you, Alexis.
Hi, I'm Alexis. Emerging Media Studies, Boston University.
Thank you so much, Alexis. You are totally right, and actually one of the things that I have found more interesting about this research that I'm doing, which by the way is for my PhD as a whole, is the richness of information that I have found in my interviews about the history of PLSC, which I think is nowhere written yet. So I take your point. I don't want to give a lot of details here because I haven't coded my interviews for that specific, like the story of PLC. So, but of course I have information there, and I will hopefully be able to include it here to give more sense of what the community was, when was it born, etc. Thank you.
Hi, Maria. Jevin Hudson, NC Law. One overarching question, and I think two sort of questions that undergird that. The big question is sort of what's next for you with this work? I echo, I think, Woody's compliment that I think this is a really intriguing body of work that I think can lend itself to a number of different pieces. But I'm curious your thoughts, and maybe this is the next piece, I know you touched a bit on this in the PLSC pieces, how this turn and the sort of technical, legal imaginary has impacted policy on the ground. And then the sort of secondary question to that I'm curious about is, while we have this particular turn in the techno-legal imaginary towards, social justice, distributive justice, issues around automated decision-making and top-down sort of regulation, sort of like how that might have perversely impacted policy. I'm thinking about like children's privacy regulations, COSA, or many of the goals in this turn and sort of techniques that sort of appear in this transition might be undermining the imaginaries we have developed. So I'm curious sort of what's next and if those sort of fall apart of it.
Yeah, thank you, Jim. So yes, I'm looking forward to moving this research agenda forward. I'm gonna be out in the market, but in the postdocs market soon, so I have to actually write down my future things. And I'm trying to reframe myself, to be honest, because I have been framed as the person who studies scholars, and of course I do that, but I also want to study other legal actors, as I told you, right? So I study legal discussions around technology. And the values that underpin it, the possible tension that you can see there, the possible opportunities for intervention, and that's something I, for example, do, and I'm way more critical in the first paper, and I say like, hey, these ideas are related to what's going on at the FTC with the commercial surveillance rulemaking. So this is the opportunity to act if you want this to become policy. For example, those type of things, and I want to keep doing that. But for this piece, and I'm going to rely on Ryan's piece about the scale and the reactor, STS has a very different approach, right? So it's more like, okay, I'm going to describe. I'm not going to be that prescriptive or normative. That's hard for me because I have a background in law, of course. But in this one, I was trying to be just descriptive as much as I could. What comes next, I will come back to being critical, that's my essence, but not in this piece. And I agree with you, the project I'm doing at Microsoft is actually about COSA, so I am critical about the possible perversely effects that can come from broadening privacy so much.
Hello, Kristen from UBC. This is such a fun conversation. Like, this is the most fun I've had in our last session. The whole day is awesome. So I have a silly question, and then I want to respond to Meg's brilliant questions that obviously stem from your brilliant paper. My silly question is because I have so much FOMO about PLSE, to which I have never been. But how much has We Robot, seen those hands go up, half the room is PLSE community. How much did We Robot maybe influence, or other, maybe I'm being narcissistic about our conference, influence some of what you're noticing happening at PLSE, those inter-conference or community linkages just seem really interesting too. Not that you have to add that to your paper, a thought for this room. And then to respond to Meg's questions in your paper as well, this probably says more about me than anything, but when I saw the first question, I just my initial reaction was ugh, I don't want my future vision to be shaped by regulation or by the trajectory of innovation. I want it to be shaped by something totally different. And a vision of the future that maybe isn't contingent on those things because of so much skepticism about the power dynamics of law and of innovation. And that got me thinking about the third question, what should the techno-legal imaginary be? What a brilliant thing for us to actually start articulating that explicitly, as hard as it is. But my response to that one, and take this for whatever you want, is instead of thinking about the techno-legal imaginary of the future that we as a community might write towards, what is our vision of this community as a techno-legal community for the future? Because I think so much of what you observed in your paper that's so fascinating has a lot to do, I know this has already been said, whose voices are in the room, right? So instead of us setting an imaginary, how do we set the community on a trajectory to then each have our own imaginaries? I don't know if any of this makes any sense. It's just me being really excited and responding to this conversation.
It does, Kristen. Thank you so much. And actually, I don't know why. I'm going to bring my first paper co-authored with Ryan because I think that one is very useful to answer your questions. So that one is about distinguishing privacy and this idea that the taxonomy of privacy was very useful for the field, but that now we need a new criteria. And partly, that new criteria or the discussion about that new criteria would allow us to do what you said, be more reflective, and we call that reflexibility in the paper. That's something that social scientists are really used to do, and part of it is recognizing their positionality, and that's something that I try to show here. maybe it would be useful for us as legal scholars to say, I'm standing in these values, and my values have changed over time, you know? Because that's positionality, and that's a good exercise of reflexivity. So yeah, and the other thing about this paper is that we do ask the same question you're asking. Who are the voices that are being heard and why? You know, because that social recognition criteria on which the taxonomy is based is partly based on that. Like, who are the people who kind of speak louder? And that should not be the way in which I think we should be constructing our collective scholarship.
So, well, thank you for such a fun comment.
I'm Michael from the University of Miami Law. So I have a question and a complication.
Oh.
The question is, why do you think that despite, in the last 4 or 5 years, a number of people, at least from the law, are trying to bring STS to the law conversation? That's relatively recent. Why did the two communities stay so separate so long? Was it just a different jargon, or was there something else going on? And I have no idea what the answer is. I'm really curious to know what you thought, or just write it down for some future paper. Here's the complexity, and I agree with Woody. Actually, I would. That, we robot is an IC or parallel with the LSC. I mean, when we built it, frankly, we tried to copy some of the LSC DNA. But there's a prehistory too. And that is CFP, computer stream privacy. And you got Wendy right there.
I was just going to give her the card with the address on it.
Who knows all, was there, chronicled it, and was as much as historian as she's our historian. And for those of us who are sort of the OGs of this thing, a lot of us, we had a foot in technology, got into it through CFP. But I remember going to my first CFP, I think it was the second time.
94.
94. And there was like 2, 3 legal panels. Most of them were technical. And I had no idea if I was going to make a career as a technologist. I'm hired as an administrative lawyer. So I went to this thing to find out. I found it on the internet. Didn't know anybody, didn't know anything. And I'll get in trouble for saying this, but most of the panels, most of the people seem to have no idea what they're talking about. Lawyer and former programmer. Except for one panel, was this one guy named Stuart Baker, who was clearly sharp as hell. I just didn't agree with the word he said, because he was, the general counsel of the NSA. So I thought to myself, okay, I can do this. And, who knows, but if you're going to really try to tell the whole story, CFP is a really important cursor, I think, in LSC.
I was going to tell her that.
Thank you.
I wasn't going to wait on line to tell her that.
No, thank you for that, Michael. I appreciate it. I also appreciate this. I will follow up for sure. I gotta say that I have to be less ambitious with the way in which I frame this research, because probably it's more about PLSC and the people that inspired PLSC commerce, in the sense that they were citing them, right, for the previous years. Because you're right, if I want the whole story, I should start by that conference. Probably I'm too late, but in a future project. No?
We can talk to you.
Okay.
Tim May is dead, but most of the other people are still.
Okay, perfect. So we can do that, for sure. But there are papers at my level from that era that you think intersect with this?
Papers.
It wasn't papers, it was more panels.
Oh, okay, so that's
the goal of CFP was much more to. The goal of CFP was much more to bring together people from different sides of conflict. So, for example, you have people from the rights, from the entertainment industry, promoting copyright and so forth, and then you have people who were opposed to extending copyright. Blood on the carpet was really the goal in a lot of the panels. The first CFP started by getting together hackers and law enforcement in the same room, which had never been done. That was 91. And I am told that I was not at like Michael was one of the first people I met at CFP in 1994. And it started as a way to get together these two communities that were at odds all the time and never communicating. And I'm told that the sparks really flew. And then over time, the hackers, in 1994, very quickly, the FBI arrested somebody on suspicion of being this very well-known hacker. And after that, the hackers wouldn't come, and they went off to DEF CON, and we never saw them again. And after the hackers stopped coming, the police stopped coming. And at some point, somebody said, "This conference is all lawyers now."
That's super helpful. I mean, if it was just about panels, it's way easier to keep working on it through interviews. So I will reach out for sure. Thank you.
Hi, I'm Satoshi Narihara. I'm Information Master at Kyushu University in Japan. I wonder if the transition of U.S. privacy scholars techno-legal imaginaries entails changes of their images of human. Do you think how did images their images of human change over recent years? For example, do you think current U.S. privacy scholars challenge personal autonomy and rational decision making in general, and so abandon the old-fashioned approach of the right to control their own data, instead try to introduce an entirely alternative approach to protect all people? Otherwise, do you think they don't challenge personal autonomy in general? They just focus on vulnerable people and minorities. So they try to introduce government intervention to protect their autonomy under the limited circumstances.
Thank you. That's a very good question, because actually somebody at PLC told me, and I agree, they have not abandoned it. They still think that autonomy is key in this. The difference is that now they assume it's like it should be given, you should not fight for it. Like, we all know that it's essential. So they have been changing the instruments. So in your question, control did change. I do think that the control paradigm has been criticized for a lot of time, and now they're trying to leave it behind. But the ideal of protecting autonomy has not changed. It's just that they have added new values that they think privacy can also protect.
Thank you for your clear answer.
Do you not answer anymore?
Yep. Okay. You get to just take some notes here. We're gonna collect some questions. Go ahead, Andrew.
Andrew Stubbs, UCLA School of Law. Hi, Maria. I've got a couple of thoughts that are connected that are related both to this paper and your last one. I was on PLC this year, so I didn't get to talk to you about it. But it seems that to me that there are a bunch of privacy. Privacy has lots of meanings, but like in one sense, right? In the sense that there's a body of law that is privacy law. There is a body of, or a collection, a community of privacy scholars. There is, concepts that either exist in privacy or not, and then let's just go with those for now, right? There are, at different times it seems you treat groups of privacy, and then there's PLSC, right? It seems like it's not clear to me through this paper that you have a solid through line where you're consistent on basically any of these. Mm-hmm. So you spend a lot of time talking about PLC, but then as others have mentioned, go into joining the pre-PLC, and PLC started in 2008, I think, yes. Right? So anything before that is pre-PLC. So if you're focused on PLC and the history of PLC as your topic, then I don't, unless you're discussing them as precursors to PLC rather than as the privacy law field, I don't understand what the historical folks are doing. But if you're thinking it more broadly as privacy law scholars, then to bring it to building on Woody's comments and other folks, privacy law scholars do a lot more than go to PLSC, right? They interact with people at other scholars at other conferences like CFP, like WeRobot, like FACT, right? And things like that. And then some of the movements you've made are movements that either movements that privacy scholars have done or movements that privacy law has done, and it's not clear to me which. And so this also relates to your last paper. And obviously I'm now going to say, oh, the one time you said it me, I'm going to put you that. But basically, right? So your last paper was about the algorithmic chart.
Yes.
Right? And here you talk about how privacy scholars started thinking more about equality and resisting power structures. Sometimes that's done through privacy law, but sometimes it's been done through the reconception of what is within the field of privacy, right? So when privacy scholars started thinking more about equality, it was partially because discrimination law became part of the conversation that is acceptable to discuss at a privacy law conference, right? And similar things happened with We Robot, where it was robots, and then it became AI, and then things like bias also came in there, right? It's not necessarily obvious to me that that is a move that privacy law made so much as the community of scholars that constitute privacy scholars made, if that makes sense.
Yes.
And so I'd love to see some more, like a little tighter clarification around what you think is going on, whether and when we're talking about the community of privacy scholars, how they've changed, how they've reshaped what they consider part of their field, versus the body of law and the work that that body of law can do, as opposed to another body of law. And I don't know, honestly, whether that's this paper or the other paper, or both, but it's just like all these interlocking things going on that I think we're flowing together a little bit, and I was maybe hoping to see parts of it.
Yeah, I can't. Okay,
Yeah,
thank you.
You just have to absorb that.
Okay.
No, you can respond at the end.
Paul Calhoun, representing myself. One of the critiques I recalled yesterday of the Agile process for ethical design was that would not be able to design ethically in a lot of cases because the technology being designed would be utilized and appropriated in ways that would not be expected by the designer.
Yes.
It seems as if that is using the imaginaries of a large community to attempt to design better. And that there was a critique there by that, while iterative, it might still lack a course correction until you hit operations and maintenance, I suppose. So this also seems to be leading the curve. So what is the course correction method, the way of correcting a law whose premise is based on an imaginary that didn't occur?
Do you understand that comment?
Yeah.
Is that it? Okay.
Please.
Margot, Kaminski, Colorado Law. So, 3 things, brief. The way you described to Meg your definition of techno-legal imaginary, I think is the way that you should describe it in the paper.
Okay.
I wrote it down, but roughly paraphrasing from 20 minutes ago when I was sitting in my seat. It was a vision of technology subject to legal interventions or consequential to legal interventions. So that was reflecting that back to you. Second point, I agree with Kristen. I felt deeply uncomfortable doing Meg's exercises. And I think that's because, as Nicholson said, I largely think of my work as a product of criticism. And so to think that I'm actually part of a project of building towards a particular unified goal is very disconcerting. So let's leave it at that. And then the last point is, reading your piece, I thought of intellectual history in legal academia, and I wish you would do some more of it. And what I mean is, there are several classic papers, both outside of privacy law and then even within privacy law, that are not yet in your world here, because they're not really PLSC papers, that take what we think is something that's happening in a very specific field and say, actually, this is about some way bigger force. So one classic move like this is when Oren Bracha writes about the intellectual history of copyright law. He says, we think we're talking about originality doctrine and authorship and copyright, but we're actually talking about is a much broader move to disable judges' judicial discretion and instead have the judge be like a technocrat who's exercising the legislature's will.
That's one example. When I think of the privacy context, I think of like the Reinberg and Whitman stuff about, these totally disparate, whether you agree or disagree, democratic cultures of regulation in Europe and in the United States. And so I wonder if some of the techno-legal imaginary change that's happening here is not actually privacy change, it's something else and it's bigger, and these are forces beyond the walls of PLSD, and just situating that a little bit, and that I think would be good for the project.
Perfect, thank you.
And now I'm stopping us from being done.
Oh no.
I'm Katie Salegi, I'm from the University of Manitoba. I was going to say kind of what Margot said, which was that definition you gave here was really helpful because I thought was looking for more in the paper about the techno-legal imaginary and your vision of it. And I wonder in a future draft or in your dissertation if you want to go more deeply into the stuff that like Sheila Jasanoff talks about and just like connecting those ideas of the imaginary. Because when you get further into it, it really starts to read more like an oral history or like a narrative project, and I think that idea of narrative in STS and in legal scholarship is broader and deeper, and there could maybe be some more connections you could tease out. Full disclosure, I did a piece earlier this year on like science fiction as a legal imaginary, which was fun. It was a collection from an Australian guy called Kieran Tranter who wrote a bunch of stuff.
Yeah.
Okay. Yeah, and I like some of those ideas, and I thought that might be useful for you. And the other thing, I also have never been to PLSD and have all this FOMO like Kristen, but when I saw the way you were discussing those ideas in conversation, I wanted to plug a paper that Ian Kerr wrote called Schrodinger's Robot, where he sort of does, I think, something similar in trying to track some of those development of those ideas, and then he develops it relationally in relation to what he calls privacy's other. But he talks about a lot of the same scholars that you do, and I think it just might be helpful for you. So.
Great, thank you so much.
So I feel like the last couple of questions give you lots to think about, but one that I would love to hear your thoughts on that I think was throughout the questions is, I don't know why the pivot happened. Do you know what I mean? Like I read it and I understand, you've convinced me that it did happen, but I think that your reviewers in STS will also want to know why you think this happened. And I think that's a little bit of Margot's second point was like, there was a lot of like social upheaval around a lot of the themes that are in the second era that you describe. And maybe that's what you think happened. I really want to know why you think this shift happened, and I don't think the article is totally done until you tell me why.
Okay, I think that's a hard question in the sense that it's a chicken and egg thing. So first, in my first paper, I was trying to say there has been a shift in the legal reasoning, right? They were focused on these harms and these proposals, and then they shift. And in this one, I'm trying to give a possible cause of that shift. So now you're asking me to actually give a possible cause of this cause. So I don't know where to start. To be fair, in the first paper, this is not the only cause that I address. I also talk about other, because I frame them as one technical reason, one social reason, like the different cognitive reason and legal reason. So the cognitive reason, I mentioned a change in imaginaries, right? But there are other reasons that I mentioned there and many others that I don't mention there that probably in this complexity may be playing a role. So there I say, for example, that it might be said that people here are trying to catch up with Europeans who have already tried to broaden the type of harms, but I actually say no, that's not the case, or it doesn't mimic exactly what's going on in Europe. That's the social, I believe, or not the legal, sorry. The social is scholars are tired of not being able to show a violation of privacy in courts, so they are changing their strategy by bringing, for example, harms to values that are more valuable for society, such as equality, and that are more cognizable. That's another. But that's a way to say I have considered other like social reasons, legal reasons that may be playing into this. But of course, there is a point where I have to stop it, right? Because that's part of the complexity that we want to show in STS, that there are many things going on. Probably one of the things that I do want to dig deeper is on the social things that were going on in this community. And to take what Andrew was saying, I want to focus on this community, and I take your point. I want to be much more clear about the fact that I'm focusing on the PLC community, right? Because there is much more going on there. And definitely I'm not focusing on the privacy law as a body of law. I'm not seeing what has happened in the law. In many places, you could see some reflections of this, but I'm focusing on scholarship and the scholarship of this specific community. But I want to be mindful of the fact that I haven't been clear enough again, I think, because that was something that happened at PLC, as how narrow my community is.
Yeah, great. Well, I want to thank Maria for giving me this opportunity to make you all so uncomfortable. So that was very nice. Yes, thank you.